your voice was quite soft. You might wish to do.
Okay, we might have lost the CJ.
Yeah, I think the Chief Justice has been disconnected.
Yes, yeah, he's no longer on the participants list. Oh, but he is.
Okay, I'm sorry. That was the first technological problem. I was saying, Mr. Sonepol, we need to hear you. When you placed yourself on record, you were not very audible. So, so make sure that we can hear you when you address us. I just repeat that each party will have 30 minutes of address without interruption. And during that 30 minutes, they ought to deal with all the important points that they want to deal with, because after that, they can only answer questions from the justices. Thank you. Your 30 minutes, Mr. Sonepol, starts now. I will tell you when you are left with 5 minutes before the expiry of 30 minutes so that you wrap up. But when it's 30 minutes, I will let you know, and your address will need to cease immediately. Thank you.
May it please the court, may it please you, Chief Justice and Justices of the Constitutional Court, with your permission, may we start in our address by giving an outline of what we intend to present to the court as part of the oral argument on behalf of the applicant in this application. Chief Justice, I will speak as loud as possible, and I trust and sincerely hope that I'm audible on your side and on the side of all the justices of this court. Firstly,
yes, I can hear you now.
Thank you, Chief Justice. Firstly, we will present a short introduction and an overview of what we deem relevant and necessary for purposes of discussion of this present application for leave to appeal. And if indeed the application for leave to appeal is granted, also in terms of your directive, Chief Justice, we will deal with the grounds of the appeal themselves. Secondly, Chief Justice, with your and the Justice's permission, we intend to, in particular, deal after the introduction portion of our address with the application for leave to appeal. In the third instance, Chief Justice, Justices, we intend to briefly deal with the merits of the appeal, and that would, in the fourth instance and lastly, include an overview of the judgment granted by the Supreme Court of Appeal. Firstly, from an introductory perspective, Justices, this case concerns the Promotion of Administrative Justice Act. Its interpretation, which we contend, is manifestly a constitutional matter under adjudication and consideration. It therefore concerns administrative justice, inclusive of the right of access to a court. In particular, it concerns the question whether the PAJA and the Value-Added Tax Acts, those legislation and their texts were interpreted in a constitutionally compliant manner by the Honorable Supreme Court of Appeal in its judgment under consideration in this application. Lastly, insofar as it concerns the provisions of the Value-Added Tax Act, it concerns the question whether the respondent, the Commissioner for SARS, or SARS in short, correctly applied the relevant export regulations, the subordinate legislation, in considering the request addressed to it on behalf of the applicant on 6 July 2015, namely that the Commissioner is to grant an extension of the relevant time period within which to claim a refund of value-added tax paid by the applicant in its capacity as the qualifying purchaser as defined in the export regulations. All of that, Chief Justice and Justices, of course, in the context of an exportation of goods, movable goods, by the applicant, who is and was at all relevant times a non-vendor, in circumstances where there occurred no local consumption of those movable goods, and further in circumstances, Justices, where value-added tax was indeed paid by the applicant to the supplier known as Sasol Catalyst, who is indeed a South African resident corporate entity, a taxpayer, and also a value-added tax vendor. The case we submit with respect, as part of our introductory address, is not a case in which it is necessary for this court to A, develop the common law, and B, it is also not necessary for this court to adjudicate the question as regards the applicant's entitlement to a value-added tax refund. What is expressly under consideration, Chief Justice, Justices, is the question whether or not the Commissioner acted correctly when he rejected the applicant's request for extension of the time period within which the applicant would be permitted to submit an application for a refund of the value-added tax act, the value-added tax, I beg your pardon, paid by it. Therefore, Justices, immediately, with your permission, if I may, move over to the question whether or not indeed the application for leave to appeal should be granted. Of course, we are cognizant of the fact that that consideration stands on two legs. Firstly, whether or not this court's jurisdiction is engaged, that is dependent on whether or not a constitutional matter serves before this court for consideration and its adjudication. And secondly, the question of the interests of justice, whether it would be in the interests of justice for this court to grant leave to appeal, insofar as it concerns the question whether or not a constitutional matter serves before this court as part of this application. We contend respectfully that it's only necessary to have regard to the first paragraph of our learned friends' heads of argument, wherein it is expressly stated that the matter concerns the proper interpretation of two pieces of legislation. Firstly, the Promotion of Administrative Justice Act, or PAJA in short, and secondly, the Value Added Tax Act, or the VAT Act in short. It has been held by Justice Brandt, writing for this court in the unanimous judgment in the matter of Camps Bay Ratepayers Association, that manifestly always the consideration of the interpretation of the Promotion of Administrative Justice Act is always a constitutional matter. We submit respectfully that indeed a constitutional matter for adjudication serves before this honorable court, insofar as it concerns the question whether or not it would be in the interests of justice to grant the application for leave to appeal. We submit with respect, Chief Justice, Justices, that indeed there exist good prospects of success on the merits of the appeal. In addition thereto, insofar as it concerns the provisions of the Constitution of the Republic of South Africa, we submit that this court, in terms of section 167, subsection 3, may not only decide constitutional matters, but also any other matter, if the court is indeed amenable to grant leave to appeal on the basis that the matter raises an arguable point of law of general public importance, which ought to be considered by this court. Of course, justices, in our heads of argument, we have made substantive submissions as regards the question whether or not indeed this matter raise questions of general importance. You would have noted our submissions to the effect that this case is not only of importance to the applicant and the respondent, the Commissioner for the South African Revenue Service, but also for the public in general, and in particular, other taxpayers and even other non-taxpayers and non-vendors that is involved in commerce in the Republic of South Africa, and that may in future find themselves in the shoes of a qualifying purchaser as per the export regulations which we deal with in our heads of argument, and in respect of which I will revert to in a moment's time. On that basis, we submit that indeed, A, constitutional matter serves before the court, B, it would be in the interests of justice to grant the application for leave to appeal. Chief Justice, Justices, if I may immediately move over to the next aspect of our intended address, namely the merits of the appeal which serves before this honourable court in the event that the application for leave to appeal is granted. Of course, I do so in the context of being aware that this only becomes relevant if the application for leave to appeal is indeed granted. We submit respectfully, Chief Justice, Justices, that a consideration of the Supreme Court of Appeal's judgment involves two sub-aspects. The first is whether or not that honourable court correctly determined that the relevant date for purposes of Section 7 of the Promotion of Administrative Justice Act, on which the 180-day prescribed time period within which a review application in respect of administrative action is to be brought, whether it was correctly held by the Supreme Court of Appeal that based on the facts of the present matter, that start date was indeed 6 December or the day after 6 December 2017. That, Chief Justice, Justices, is of course the date of the impugned decision to which reference is made in prayer 1 of the applicant's notice of motion in the High Court, the Court of First Instance in the present matter. The second consideration is whether or not, as part of this consideration, the Supreme Court of Appeal was correct, based on the facts of this case, to hold that indeed the date on which the reasons for the administrative action were furnished by the respondent to the applicant, i.e. 26 March 2018, is not the operative date for purposes of calculation of the 180-day time period. The second component, Chief Justice, Justices, of the Honourable Supreme Court of Appeal's judgment, that is, we respectfully submit up for consideration and adjudication as part of the merits of this application and the appeal itself, is whether or not that court correctly interpreted Section 7, subsection 1 of PAJA, where it refers to the requirement that a review application must be instituted within 180 days, either after the administrative action, the decision as defined in Section 1 of PAJA was indeed taken, or with reference to the date on which reasons were furnished, whether the Supreme Court of Appeal correctly determined and held that instituted in the circumstances means the issuing as well as the service of the application on this respondent. We contend, firstly, as regards the interpretation and consideration of the judgment by the Supreme Court of Appeal, that there served nothing before the Supreme Court of Appeal at a factual level, which rendered necessary the finding that the operative date for purposes of commencement of the 180-day time period was not the date on which reasons were furnished by the respondent to the applicant, i.e. 26 March 2018, but that it should be 6 December 2017. In this respect, Chief Justice, Justices, it is relevant to be aware of the fact that in the respondent's initial answering affidavit in the court of first instance, it did not take the point that with reference to the date on which the reasons were furnished in respect of the decision, the impugned decision taken on 6 December 2017, the 180-day prescribed time period provision was transgressed by the applicant. That point was not taken in the answering affidavit in the court or quo. Despite that, there was the explanation on behalf of the applicant in its replying affidavit to the effect that after the decision was taken on 6 December 2017, i.e. the impugned decision, in respect of which the notice of motion relief is aimed, the review relief, reasons were sought on behalf of the applicant via its attorneys of record in a letter addressed to the respondent in February 2018. In response thereto, the respondent did not assert that it's unnecessary in the circumstances to provide the requested reasons because sufficient reasons had already been furnished. No, what emanated was that on 26 March 2018, the reasons were indeed provided. And those reasons is to be found on the record, page 110 to 112 of volume 2. And if one bears in mind the fact that in circumstances where the respondent did not impugn at the stage of the initial delivery of its answering affidavit in the court of first instance, the fact that the review application was not instituted late, it must be so that when the Supreme Court of Appeal held that the review application was indeed instituted late, that was a miro moto point raised by the Supreme Court of Appeal that did not constitute an issue in dispute between the parties in the court or quo, the court of first instance, the High Court. Indeed, it is recognized by the applicant that the respondent did, as part of its answering affidavit, dispute that the review application was instituted, to use the terminology contained in section 7.1 of PAJA, late, but that was done on the basis, firstly, that it was asserted on behalf of the respondent that the relevant administrative action, i.e. the decision, was the decision of November 2016, a point that was later jettisoned on behalf of the respondent at the time of the Supreme Court of Appeal hearing. And secondly, indeed, the respondent did, in its initial court of first instance answering affidavit, assert that with reference to the date of the impugned decision, namely 6 December 2017, the application for review and setting aside of that decision was instituted late. But importantly, Chief Justice, Justices, the respondent did not assert as part of its defense and the plea raised on its behalf in its answering affidavit that with a reference to the date on which reasons were provided, the application was still instituted out of or outside the prescribed time period. Secondly, insofar as it concerns the decision by the Supreme Court of Appeal and its finding that instituted, where it appears in where the word appears in section 7.1 of PAJA must be understood to mean issue and serve, we respectfully submit that that does not constitute a constitutionally compliant interpretation of the provision in the circumstances. But, Chief Justice and Justices, even if it does, we have in our heads of argument made the point that based on this court's judgment in the matter of Camps Bay Ratepayers Association, and in particular the dicta which appear in that judgment on page 65 of the reported judgment, paragraph 54 in square brackets, where it was held by this court that a court will only raise section 7.1 of PAJA of its own accord where the delay is manifestly inordinate, and even then, only when the applicant had been given an opportunity to explain the delay. What we submit, therefore, Chief Justice, is irrespective of the interpretation and by the Honourable Supreme Court of Appeal of the term institute, where it appears in section 7.1 of PAJA, it matters not, and it may not even in the present matter be necessary for this court to give a definitive answer to that question, because the failure with respect by the Supreme Court of Appeal to abide the direction given by this court in Camps Bay Ratepayers Association, paragraph 54, was not adhered by the Supreme Court of Appeal at the time when it raised miro moto the question of non-compliance with the 180-day time period. That, of course, Justices, in the context of the fact that the respondent did not attempt to, in its answering affidavit in the High Court, impugn or address or assert any lateness in respect of the application. Lastly, Chief Justice and Justices, insofar as it concerns the merits, the substantive value-added tax merits and the considerations from a value-added tax perspective of this application, we submit that there is really, Justices, quite a simple and with respect, straightforward manner in which the Value-Added Tax Act provisions, as well as the export regulations, ought to be interpreted in the circumstances. And our arguments in that regard, Justices, is as follows. One would have noted from the heads of argument of our learned colleagues on behalf of the respondent, and also from a reading of the answering affidavit in the application which serves before this Honourable Court for leave to appeal, that the respondent makes a lot of the fact that the relevant tax invoices can and should only be the original zero-rated tax invoices. That's the one argument raised by the respondent. The next argument raised on behalf of the respondent is that the movable goods were exported by the applicant outside of the prescribed 90-day time period with reference to only the original zero-rated tax invoices. And the last argument, insofar as it concerns these considerations made on behalf of the respondent, Justices, is that with reference to the value-added tax export regulations, once a vendor, such as Sasol Catalyst, who is the supplier in the factual context of this matter, makes an election to put itself under the rubric of Part 2 of the export regulations, so that the respondent asserts it is thereafter never possible for that vendor to resort under the provisions of Part 1 of the export regulations. We submit that that position and argument adopted on behalf of the respondent ignores the Regulation 6.6, and in particular its proviso, which provides for circumstances where there may have occurred an incorrect zero rating by the vendor who made the initial supply. That is exactly what happened in the present instance, Justices. In those circumstances, Regulation 6, subparagraph 6, provides, therefore, that the qualifying purchaser can subsequently pay the relevant value-added tax and can thereafter claim a refund, which is also exactly what happened in the factual context of this case. The reason why in November 2016, the request for extension of the time period within which to submit the VAT refund was rejected appears from a reading of page 92 in volume 1 of the record, in particular in paragraph 5.4, where the Commissioner held that no extension is granted in terms of the regulation 6.6b. And the reason provided is this: as the goods were not exported from the Republic within 90 days from the date of the tax invoices. Of course, Justices, there can be no other interpretation attributed to this reason on which the respondent relied other than it or he referred to the original zero-rated tax invoices. We submit that that is in fact incorrect, and the only relevant consideration must be with reference to the reissued or new tax invoices, which it is important to emphasize as part of our address, Justices, were never impugned by the respondent. The replacement or new tax invoices were and remained the only extant tax invoices of the supplier Sasol Catalyst. They were not issued, of course, by the qualifying.
You have 5 minutes left.
May it please you, Chief Justice.
You.
The only extant tax invoices remained the new tax invoices, and the question whether or not an extension of the time period within which to claim the refund ought to have been granted must be with a reference to the date of those tax invoices. Lastly, Chief Justice and Justices, insofar as the respondent has contended that the so-called election theory defense finds application, i.e., as soon as the vendor elects to apply part 2 of the export regulations, it is never open for that vendor to go back and resort to part 1. We submit that that position and argument is manifestly incorrect. Firstly, because Regulation 6.6 exists and makes provision for mistakes in the original zero rating. And secondly, it of course ignores the entitlement in terms of Regulation 8, subparagraph 3 of the export regulations, which provides that a vendor who has subsequently paid the value-added tax can claim the VAT refund. And in the third instance, Justices, it would of course be incorrect to say that the vendor who paid subsequent to zero rating, when new tax invoices were indeed raised by the supplying vendor, the qualifying purchaser who paid the value-added tax must his or its request for extension of the time period must be considered with reference to the zero-rated tax invoices cannot be correct in circumstances where that qualifying purchaser, who is of course not a vendor in the context of this discussion, cannot claim his input tax deductions with reference to zero-rated tax invoices. It must be with reference to the new tax invoices, the so-called standard-rated tax invoices. So we submit that on that basis alone, the respondent's contentions that once you have elected as a vendor part 2, part 1 can never apply is manifestly incorrect, and we submit that the respondent's assertion that reliance must be placed on the old tax invoices in order to determine whether the request for extension of the time period to submit the value-added tax refund was timeously made. One last issue that I need to quickly just direct attention to, Chief Justices, is that the relevant request directed on behalf of the applicant to the respondent only for extension of the time period within which to request an extension, to request a payment of the refund was made on 6 July 2015. After exportation, after the new tax invoices were already issued by the vendor, Sasol Catalyst, to this applicant, and you'll find that in the founding affidavit on page 21, paragraph 24, and also annexure I attached to the founding affidavit in the court of first instance, pages 59 to 61. On that basis, we submit, Justices, that indeed a case has been made for leave to appeal to be granted, and insofar as it concerns the merits of the appeal, we submit that indeed good prospects of success exist. We will ask that the appeal be upheld with costs, and that the Supreme Court of Appeal's decision and judgment be, well, its order be set aside. An ultimate last issue that I need to direct attention to is, of course, the fact that it is not necessary for this court to make a decision on behalf of the administrative functionary. The court of first instance granted the review relief and referred the matter back to the respondent for its or his reconsideration. May it please you, Chief Justice.
Thank you very much, Mr. Sonepol. You were spot on with the time. Thank you very much. If there are questions from colleagues, they will now get the chance to put questions to you. But if they aren't, then we will move to the Respondents' Council. Colleagues.
Can I ask Mr. Swanepoel, you made the submission that this court need only decide whether SARS was correct in refusing the request for extension. Now, one of the points that is made by Mr. Sholto Douglas in his written submissions, at least, is that you should have, he says you are seeking a review of the impugned decision of 6 December 2017. That's in the first paragraph of the notice of motion at page 2 in volume 1. He says that you should have asked for an amendment of this notice of motion, specifically paragraph 1, because I think he suggests that what you are seeking to attack now and to challenge under PAJA is the decision or the reasons of 26 March, and not the one of 6 December. What do you say about that submission?
Thank you very much, Justice Majid. Firstly, we submit that the applicant has indeed correctly, in its notice of motion, identified the decision. What the respondent, we submit, respectfully loses sight of, Justices, is the fact that the term decision is defined in section 1 of PAJA. Secondly, what the respondent loses sight of in that argument of it is that in the matter of Camps Bay Ratepayers and Residents Association, that is the decision by this honourable court, the judgment written by His Lordship, Mr. Justice Brandt, AJ, as he was, and which is a unanimous judgment of this court. On page 66 of the reported judgment, in paragraph 57 in square brackets, reference was made, amongst others, to the relevant administrative action. And it was held by the court in that paragraph that according to the definition of that term in PAJA, the decision that is challenged in the review proceedings is indeed the relevant administrative action. One must therefore consider that the impugned decision is and remained the 6 December 2017 decision, but the operative date for purposes of determining whether or not the applicant fell of the provisions in section 7.1 of that act, which prescribes a 180-day time period within which the application had to be instituted is a separate consideration. It is, of course, not an instance where the relevant review relief would lie against the reasons, similar to an appeal to a higher court against the judgment and order of an earlier court. The appeal is against the judgment and the order. Here, as soon as the applicant, as it did, highlighted the relevant administrative action, it of course included the reasons provided on 26 March 2018. Our submission is that it is wholly unnecessary for the applicant to also, in addition to identifying the decision as defined, to also impugn by way of citing in the relief sought by it, the reasons given at a later stage. That, Justice Majid, of course, in the context of the fact that reasons and its provision by the respondent to the applicant on 26 March 2018 was an issue that was fully canvassed by the applicant in its founding affidavit in the High Court. May it please you, Justice Majid.
Thank you. Can I just follow up on that? And I'd like to take you to the reasons or to the decision. You say it's not reasons, but to the decision impugned, and that's the one at page 105 at volume 2 of the record. That is SARS's reasons. They say it's reasons, but let's call it a ruling for now of 6 December 2017. And in particular, paragraphs 1 to 3 of that response. That followed, of course, upon your letters your attorney's letters that had been sent. And in paragraphs 1, 2, and 3, SARS's response is that A, when you issued the invoices, you did so at VAT 0 rated as contemplated in part 2 of the regulations. That's point 1. Point 2, it may make the point that because you had not exported within 90 days, the standard VAT rate of 14% must be applied. And 3, that seeing that Sasol Catalyst has elected to export the goods in terms of section 11(1)(8) Roman 2, read with part 2, the section 11(a)(2)(bb) read with part 1 cannot apply. So there, in effect, they're telling you that once you've elected to zero rate, you cannot then change afterwards if you hadn't met the requirement of export within 90 days. What in those 3 paragraphs do you say, Mr. Swanepoel, were inadequate for you to launch a PAJA application?
Justice Majid, if one has regard to those 3 paragraphs, and firstly, the reference to the incorrect 0 rating, that incorrect 0 rating was not an action performed by the applicant, who was only the qualifying purchaser. And of course, as I've already mentioned, Justice Majid, justices, not a resident, not a taxpayer, and not a VAT vendor. The second reference to the fact that it was at that time already, this is October 2017, in correspondence addressed to the applicant's attorney, mentioned that standard rated VAT ought to be levied. That is, again, a direction aimed at the vendor, because the qualifying purchaser can do nothing about the situation. It purchases the goods and it receives the relevant tax invoices. If they are 0 rated, of course, then it has certain obligations. If they are standard rated, one of the obligations of the qualifying purchaser, i.e. the applicant in this application and appeal, Justice Majid, would of course be to make payment of the consideration as expressed in the tax invoice. And we say that is, from the perspective, should be seen as the new tax invoices. And the third issue, the reference to the fact that Sasol Catalyst, the supplying vendor, has made an election to bring itself under the rubric of part 2 of the export regulations, is, in the third place, again, a repeat of the theme adopted in its approach by the respondent, namely to say that Sasol Catalyst ought to have 0 rated, not to have 0 rated, I beg your pardon, it ought to have standard rated, and it made an election. But it does not address a question from the perspective of the applicant the qualifying purchaser, and it does not say to it, what have you done wrong? Why can you not resort under the provisions of Regulation 6, sub 6, which provides for mistakes that can be made and thereafter putting it right? How? Firstly, you can pay the VAT. If you pay the VAT, you can claim the refund. Of course, even before you claim the refund, Justice Majid and Justices, if it's necessary, ask the commissioner, who is the designated administrative functionary, for an extension of the time period within which to submit your refund claim, if necessary, if you want to do so, or if you must do so in the circumstances, and thereafter only submit your claim or request for a refund of the VAT that you paid, but not to SARS, not to the commissioner, but to the designated official in terms of the Value Added Tax Act, read with the export regulations, who is the VAT refund administrator. And curiously, Justice Majid, that culminated in the decision of 6 December 2017, where, as you would have noted, Justice Majid, on page 106 of volume 2 of the record, in paragraph 4, pursuant to a request only for extension of the time period within which to claim the refund, the respondent says this: as a result, the recipients of the goods, which is the applicant, is not entitled to a refund. We say, with respect, what the respondent did there is he, because he is a gentleman at present, he and his officials ignored the request, took a leap to the later stage of proceedings and considered for himself that, well, I'm confronted with a request for extension, but I already have in mind that you won't be entitled to your refund. Therefore, I just respond back by saying, you're not entitled to a refund. So the request was ignored. And the response was, you can't have your refund. Also bearing in mind that the respondent who took this impugned decision was at no relevant stage the designated functionary to take the decision. He was not the VAT refund administrator, and no request for a refund served before him. Even if our approach is incorrect to regard this as to be understood to mean you're not entitled to your refund, if this must be interpreted to mean, I hear that you ask, applicant, for an extension of the time period, but because you are not entitled to a refund, I decline your request for extension of the time period. Even then, we say that no reasons were advanced qua the applicant as to what it did not do correctly.
Mr. Swanepoel, thank you. I was just going to say that I think I'm covered there. But what you are saying is that what you had asked for in at page 102, I'm just taking one of the pages at page 102, just a few pages earlier, is you telephonically asked for an extension to claim the refund, and then SAR said, well, put pen to paper, figuratively speaking, and request in writing a refund. And what you got was paragraph 4. That's what you're saying.
May it please you, Justice Majid.
Then I have one last question. Thank you. Well, it's actually on a factual basis. Am I correct that the upshot of all of this is that Sasol Catalyst paid tax in Nigeria for the goods that was exported there or imported into Nigeria? And then Sasol Chevron, the applicant here, had to pay tax, VAT to Sasol Catalyst. So is that what's happened here on a factual basis?
Might please you, Justice Majid. No, with great respect, Justice Majid, as I understand it, and this is our understanding, what happened here is the goods were eventually exported, and those are the facts, by the applicant. The applicant purchased, and this is common cause, the goods firstly on a flash title basis. The international commercial terms, as I understand it, Justices, simply means that it takes ownership of these movable goods, the catalysts, only for a moment in time. very quickly that passes and ownership is transferred to Escravos, the Nigerian entity who purchased the goods at some point in time thereafter, but very quickly thereafter. But also it's common cause throughout the papers since the proceedings in the court of first instance that the goods were sold by Catalyst, the vendor, to Chevron, the applicant qualifying purchaser, on an ex-works basis. Of course, what that means, as explained in the founding affidavit, is that the qualifying purchaser, the applicant, takes responsibility contractually for transportation of the goods. And I do not think there's any dispute about the fact, Justice Majid, that indeed, eventually on 24 April 2015, when the exportation of the movable goods occurred, that was as a consequence of actions taken by the applicant in its capacity as qualifying purchaser. To answer your question about the potential double taxation consequences that arose at a factual level, Justice Majid, our understanding is that no double taxation occurred by reason of the fact that a value-added tax was paid here on the assumption that the refund will be paid to the qualifying purchaser, i.e. Sasol Chevron, the applicant in this case. That is part of that regime which finds application. So although it had not yet submitted its claim or request for a refund, if it is granted by the commissioner upon this matter being referred back to the commissioner, an extension of the time period within which to require such to submit such a request for a refund, then of course there would arise no double taxation. But qua its position as the importer into the country of Nigeria, the foreign jurisdiction, of course, on importation, as explained in the affidavits of record, and I'll reference the page in a moment's time, Justices, there would be double taxation in the hands of the applicant if with its hat on as the importer into the foreign jurisdiction, it must again pay VAT, which it would be obliged to do because local consumption would occur in the foreign jurisdiction. So in circumstances where there had never been local consumption within our jurisdiction in the Republic of South Africa, the applicant's submission is that the VAT regime must be correctly interpreted to mean that indeed where reference in section 11A is made to shall be refunded, and the refund provided for in section 44 subsection 9 of the VAT Act, that must be adhered to because there was no local consumption. Firstly, but that is a stage that will be attained later on, of course, if the commissioner, on referring the matter back to him, decides to grant the request for an extension. So double taxation will only occur, Justice Majid, if the refund, which is a future consideration, is indeed not paid to Sasol Chevron, the applicant in this application.
Thank you. Thank you, Chief Justice.
Thank you, Justice.
Thank you. I don't see any other indication.
Chief Justice, can I
Yes.
pose a question to you, please, Mr. Swanepoel? Mr. Swanepoel, one of the core issues, as you point out, for us to determine is when was SARS decisions taken and when were the reasons furnished for that decision? Now, you point out that the 6th of December decision did not provide reasons, and your attorney's letter of the 12th of February sought those reasons. Those reasons were then furnished on the 26th of March, and that's when you say the clock started running. However, can I just take you to the correspondence, not in great detail, but if you look at SARS's letter of the 26th of March, it's a long letter, but really the first two parts of the letter sets out the background. The second part of the letter sort of reiterates your client's request, which is contained in the letter of Cliff Decker. And really on the last page only, under paragraph 3, there's a heading, Reasons for the Decision by SARS. Now, when I compare those reasons, which are set out in 7 bullet points, to the reasons in inverted commas from your perspective provided by SARS in its letter of the 6th of December 2017, then by and large, they appear to be substantially the same. SARS really takes the view that the invoices were zero rated. They take the view that there was an election, and if you make the election, you're bound by the election. And that's the view they take in their letter of the 6th of December, and that's substantially the view they take in their letter of the 26th of March. To my mind, there's nothing additional in the letter of the 26th of March to that of the 6th of December, except to the extent possibly that they may expand an existing reason. But an expanding of an existing reason is not a new reason. So my question to you and my concern is that if you were in the dark, as it were, your clients were in the dark as at the 6th of December with regard to the precise reasons that SARS attached to the letter, then that same position would have prevailed after the 26th of March. Because as I read it, there's nothing in the letter of the 26th of March that would say any more to your client than the letter of the 6th of December would have said. And on that basis, while your client may have been entitled to engage SARS with a view to understanding better, it could not detract from the fact that SARS may well have, as they say, made a decision and provided the reasons on the 6th of December. And if your client elected to seek more, it did so at its own risk, mindful that the clock of prescription was ticking. What do you say to that?
May it please you, Justice Colopin, may I start? And I have 2 headings under which I would, with respect, request permission to address your question. The first is with a reference to volume 2, page 108. That, Justice Colopin, is the second letter, the second page, my apologies, of the 12th February 2018 request for reasons letter, which gave rise to the reasons being provided on 26 March. In paragraph 5, here, the applicant's attorneys write to SARS and says that it appears that SARS has reached the conclusion on the basis that Sasol Catalyst has originally elected to export the goods in terms of section 11(1)(a), sub-Roman 2 of the VAT Act, read with part 2 of the export regulation, and therefore section 11(1)(a), subparagraph 2 in brackets small bb, read with part 1 of the export regulation, is not applicable to the export of the goods. And then in paragraph 7, as part still of the request that reasons be provided, the attorneys wrote as follows: SARS has not provided any reasons for its decision and or its interpretation of the VAT Act as set out in 5 above. There does not seem to be any basis for the decision and interpretation of SARS, as the zero rating and refund is provided for in the same section of the VAT Act, i.e. section 11(1)(a) Roman 2. The legislature clearly intended that no VAT should apply to such exports. And then two lines down, still in paragraph 7, round about the middle of the page, there also does not seem to be any basis for the SARS interpretation that if VAT becomes payable under proviso AA of section 11(1)(a) Roman 2, the recipient is not entitled to a refund as provided for under provision BB of section 11. Lastly, the interpretation of SARS is in contrast with the principles of a destination-based VAT system. Now, if one then compares, as you have done as part of your question directed to me, Justice Colopin, firstly, the 6th December paragraphs 1 to 3, which appears on page 105, and thereafter, the reasons that were provided on 26 March, the manifest difference we submit is twofold. Firstly, one does not read on page 105 the impugned decision's initial 3 paragraphs, anything which pertains to or impugns the applicant from entitlement to request an extension. The refund, I understand, forms part maybe of an overall consideration in one's mind when one thinks whether or not the extension request ought to have been granted, but a refund was not requested. The point I'm trying to make is paragraphs 1, 2, and 3 is silent on any action or inaction on the side of the applicant. It impugns Sasol Catalyst. It limits Sasol Catalyst to an election. But if one reads page 112, i.e. Justice Colopin, the reasons that were provided on 26 March 2018, what one sees there in paragraph 3.4 is the assertion by the respondent that the substance or nature of the original supply was not altered. So that, of course, brings into play the applicant in its capacity as the recipient of the supply that was made by Sasol Catalyst. Now, one of the reasons stated why the applicant could not obtain the requested extension of the time period from the respondent is this fresh reason provided to it. There was no change in the supply made to you. Of course, there was a manifest change we submit, and that is that credit notes were issued, replacement tax invoices or new tax invoices were raised. This is an aspect canvassed in the founding affidavit already on behalf of the applicant, where it said that it did so pursuant to the provisions of section 21(1)(c) of the Value Added Tax Act, which is a fact that is not denied by the respondent in its original answering affidavit. And that you will find, Justice Colopin and justices, in the founding affidavit in the High Court proceedings. If you will grant me 1 second, particularly, just lost the page for a moment, particularly on page 2nd. I apologize for keeping you waiting, Justice Colopin. I'll refer to the page number in a moment's time, and the fact that this was not impugned by the respondent. And what we say is that, of course, therefore, once the applicant received these reasons, which included an assertion to the effect that there was no change in the nature of the supply, it knew then that what the respondent actually says is, I can't give you an extension of the time period. Yes, we know later on he did not on 6 December make a finding in that respect. He said, listen, you're not entitled to the refund, but let's assume for a moment he said you can't get your extension, and he did so on the basis that recipient, qualifying purchaser, the supply made to you was still in terms of the original zero-rated tax invoice. And we know that this cannot be the case because the old tax invoices ceased to exist. They are no longer in SA. The only extant tax invoices after 30 June 2015 were the new tax invoices. And this news of the asserted change in the supply made to the entity that requested the extension of the time period from the commissioner was for the first time made in the reasons provided on 26 March 2018, not before that. If I may refer you to the page number in the founding affidavit, you find that, Frank? So on page 1, I beg your pardon, volume 1, page 29, there, the justices in paragraph 48, you see that it was already stated in the founding affidavit that the original zero-rated tax invoices were cancelled in terms of section 21(1)(c), which makes, amongst others, provision for a change in the consideration by agreement between the parties. And the response thereto, Justice, you will find in the answering affidavit, page 163, paragraph 51. So we submit, Justice Colopin, indeed, all the previous so-called reasons that were provided impugned only the supplier, Sasol Catalyst, and nothing was said from the perspective of the recipient of the goods, the qualifying purchaser, and its entitlement to
It looks like Mr. Swanepoel is frozen.
be perhaps later on.
Mr. Swanepoel, can you hear me? Mr. Swanepoel, can you hear me? Oh, he's frozen for the time being. I guess we have to wait because
Chief Justice,
okay.
Justices, I
Oh,
apologize
you're
for
back. Yes, okay, all right. Do you want to complete your answer?
That's my response, Justice Colopin, Justices.
Thank you, Mr. Swanepoel. You've sort of given a substantive response, and I sort of don't want to further engage with it. I may come back to this, but I want to give an opportunity to other colleagues maybe to also put their questions, except to say that part of your letter, your attorney's letter certainly would be engaging SARS in saying to them why we think that your reasons and your interpretation is correct. That's quite a different matter for asking for better reasons. It's really saying that we think you're wrong, but maybe for now we leave it at that and we could come back to it if need be. Thank you.
May it please you, Justice Colopin.
Mr. Swanepoel, may I ask, I could find in regard to part 1 and the refund regime, I could find the provisions in Regulation 6.6 about extension, but perhaps I was being dim, but I haven't found what is the prescribed period for submitting a refund application in the first place.
Yes, may it please you, Justice Rogers. It is quite hidden in the regulations itself. You'll find it, Justice Rogers, if you turn to regulation. I actually marked it in our discussion yesterday. In Regulation 3, and the time period, it's on page 119 in volume 2, Justice Rogers.
Yes, I have the regulations, yes, Regulation 3.
Regulation 3B, Roman 2, the second sentence, which is the third last line on this page of the record, provides this application for a refund of tax must be received by the VRA within 90 days from the date of export and must contain, and then there are subsequent provisions.
Thank you. Now, your argument is that for purposes of part 1, the relevant invoices are the standard rate invoices of 30 June 2015. Is that correct?
That is correct, Justice Roger.
And the goods were exported on the 24th of April or the 25th of April 2015.
That's correct.
Is that correct?
That is correct.
90 days from and 90 days from that expired on the 23rd of July 2015.
May it please you,
Is that
Justice?
correct?
That is correct, Justice Roger.
Why, when the request was made early in July 2015, why was an extension of the period for submitting a refund required at all? Surely you were simply in your client was simply in a position to make a refund application, because on your take, unless your client's understanding of the law has changed since the time of July 2015, it was in time to make a refund application without seeking an extension at all.
Yes, Justice Rogers, that's a very brilliant question with great respect in the circumstances. And the reason for that we submit appears from a reading of what starts on page 51 in volume 1. That is the request. I beg your pardon. It starts on page 59, not page 51. The request for the extension was made on 6 July, as you've stated as part of your question, Justice Rogers. But if one notes the request for the extension in paragraph 6 on page 60 of the record, Sasol Catalyst has also considered part 1 of the export regulations, etc., etc. And then in paragraph 10, it is stated as follows. The request is made conditionally at that time, and I'll get back to the reason for that in a moment's time. We request that you grant...
Sorry, but if I can interrupt. Sorry, Mr. Swanepoel, it's by the 30th of June, there could be no question of seeking an extension for export in terms of Part 2 because there was no longer a zero rate invoice. The only regime available to the parties after 30 June 2015 was Part 1, if it could be applied at all.
Correct. So the response to your question with respect, Justice Rogers, is the request at that time was made conditionally. And the condition was stated to be, SARS, should you remain of the view that the transaction cannot be zero rated, then you are kindly requested to grant an extension to this applicant, the qualifying purchaser, to later on submit its request for a refund. That's the basis on which the request for extension was made for the first time on 6 July 2015. Indeed, of course.
I understand that, but then are you saying that this request was made on the basis that if SARS agreed to extend the period for exporting under Part 2, then you would again cancel the standard rate invoices and reissue zero rate invoices? Part 2 and the extension under Regulation 15 could only apply if the vendor at that stage was proceeding with a zero rate option. And I understand by 30 June 2015, before this request, Sasol Catalyst had abandoned that.
Sasol Catalyst, as the supplying vendor, indeed abandoned that. It issued new tax invoices on the 30th of June. 6 days thereafter, the conditional request for an extension of the time period was made. Yes, it is correct, Justice Rogers, that of course, at that time, the request ought not to have been directed on behalf of Sasol Catalyst under the rubric of Part 2 of the export regulations because it had already issued credit notes and replacement tax invoices. But the basis on which the request for extension remained at that time was conditional. And one last thing, the context of the correspondence exchanged between the representatives of the parties at that time was, of course, there was still a tug between Sasol Catalyst, the supplying vendor, and the commissioner as regards the correctness of the supply on a zero-rated basis, despite the fact that new tax invoices were issued. And this continued up until, at the very least, and at the best interpretation for the respondent, until November 2016, well beyond the time period on which, or beyond the time on which the 6th July letter of 2015 was addressed to the respondent on behalf of not only the applicant, but also Sasol Catalyst. To answer
I think you've answered that question. The other is a far more technical matter, and it concerns the meaning of institute for purposes of Section 7 of PADGA. You say institute means issued, but it doesn't require service. Now, can I just ask you, in the context of an application on notice of motion, what do you understand the act of issuing to be?
The submissions that we have made in our heads of argument deal to a large extent with the findings by the Supreme Court of Appeal in this respect. We submit that issuing in those circumstances should be the institution of the application, i.e. Issuing out of the office of the registrar of the court, as was done in this case on Friday, 21 September 2018, when the application was indeed issued out of the court in which the matter was brought. And that, of course, it is common court.
Mr. Swanepoel, it seems to me then that the notion of issuing rests on a procedural misconception as to what is involved with a notice of motion. And this distinction has been drawn in several appellate division judgments. In the case of a summons, the rules read with the prescribed forms indicate that what a summons is, it's an order by the registrar to the sheriff to notify the defendant of the plaintiff's claim. So the issuing of a summons is the issuing by the registrar of that order to the sheriff. A notice of motion on application in terms of Rule 6, again read with Forms 2 and 2A, indicate that there is nothing that is issued by the registrar. It is a notice by the applicant itself to two people If it's ex parte, it just goes to the registrar. If it's not ex parte, it's addressed to the registrar and the respondent, which is why every notice of motion, as you will recall, ends with to the registrar of the High Court, whatever, and to the respondent. So there is no act of issuance by the registrar. I appreciate that for administrative purposes, the court officials will allocate a case number and there'll be a file. But the cases to which I have in mind say that an application is perfectly valid without having yet been delivered to the registrar, and it can be served first on the respondent, maybe delivered some days later to the registrar. So there is no act of issuance equivalent to a summons in the case of a notice of motion. The only act institute must then, in relation to an application, mean something different. It must mean delivery. Because the only, unless you say an application can be issued by the applicant in the privacy of its office signing the notice of motion, but if something overt has to be done, it is surely delivery to the parties that the rule requires it to be delivered to, in whatever order that is chosen. Why should delivery to the registrar be more important than delivery to the respondent?
I appreciate that, Justice Rogers. Firstly, of course, we recognize the difference between, at the procedural level, the issuing of a summons and the actions then to be taken by the registrar and the direction to be given to the sheriff of the High Court to serve the relevant summons, and that in the circumstance application, it is dissimilar. The same function at a procedural level is, of course, you're quite right, not performed by the registrar in those circumstances. What we say is, if the legislature, when enacting Section 7.1 and prescribing the 180-day time period, had in mind the issuing and the service of the application on the respondent by the sheriff of the court, it would have said so. Of course, we are busy with an interpretative exercise, and one must attribute meaning to the term institute as it appears in Section 7.1 of the Promotion of Administrative Justice Act. And we say...
Yes, but sorry to interrupt you, but you then slipped into the phrase of issuing and service. And what I'm suggesting to you is that there is no act of issuance in the case of a notice of motion.
I appreciate that.
Sorry, and you may wish to consider this in reply. So perhaps your junior might just take a note of the SCA case I'm referring to is Finishing Touch. I won't give the full citation. It's 2012 ZASCA 49, and the relevant paragraph is 17, which then refers to the earlier appellate division judgment. So you'll pick up that reference there. And I happen to refer to this point also in a tax court judgment, which isn't on SAFLI. I think it is on the SARS website. So the important point is, if you're seeking, perhaps I can ask you this. I presume you don't say that the mere signing of the notice of motion by the attorney in his office is the institution of the application.
Definitely not. The case as it was presented in the founding papers, read with the replying affidavit, of course, in the court of first instance, was that it was issued out of the office of the registrar. And I appreciate the difference that you've alluded us to just now. And I agree respectfully with that. There is no procedural obligation then in circumstances of a high court application where Form 2A of the Uniform Rules find application that the registrar says to the sheriff, go and serve that. It's a further action that must be actioned by the representatives of the applicant wishing the application to be served by the sheriff. But our assertion is not.
Sorry, the registrar is simply one of the persons to whom an application must be delivered.
Definitely.
And
so.
he doesn't have to, the registrar doesn't have to be the first person to whom it is delivered either. So why should delivery to the registrar be the critical thing rather than delivery to the respondent?
Yes.
That's really my question.
What we say, Justice Rogers, is not that delivery to the registrar is the critical consideration. The applicant said, and its case is built on the contention that it did, out of the court, of first instance issued its application. It received the stamp of the office of the registrar. It received an allocated case number, but service thereof only occurred on the 25th of September, the day after the public holiday, which occurred on the Monday, the 24th of September 2018. What we submit is not that either the one or the other would be sufficient. That explanation was given in the context of the applicant explaining why it ought not to be regarded as falling foul of the provisions of Section 7.1 of PAJA, which stipulates a time period within which the review application had to be brought, bearing in mind that this was not a point of fact or law raised by or on behalf of the respondent in the court of first instance.
Thank you, Mr. Swanepoel.
May it please you, Justice Roger.
Mr. Swanepoel, am I right in thinking that your point with regard to institution of the application really amounts to saying that the applicant took such steps as were necessary to effectively deliver the application to the registrar and have the case registered?
May it please you, Chief Justice. It went further than that. It explains in its replying affidavit that it tried to cause the application to be served by the sheriff on the respondent on Friday, the 21st of September 2018. The sheriff could not effect service because the offices of the respondent were closed early on that business day because there was a long weekend, because the Monday, the 24th, was a recognized public holiday in terms of the applicable legislation. But the issue wasn't canvassed further by it. And the reason for that is, of course, the so-called late institution of the application as a consequence of service having only occurred outside of the 180-day calendar day time period was never raised by the respondent in the court of quo. It was an issue raised near a note by the Supreme Court of Appeal.
Yeah, but what I'm trying to establish from you is this, that when the question is posed, what is the meaning of instituting proceedings in the context of motion proceedings, given what Justice Rogers just put to you? Your answer can be nothing more than that instituting proceedings in the context of motion proceedings is delivering papers to the registrar's office and getting the case effectively registered in court so that it's known that it has been filed. That it doesn't mean anything more than that. That's what I'm understanding you to mean, because attempts to try and contact the respondent to arrange for service, I guess that's not part of what you would say instituting proceedings means in the context of motion proceedings.
May it please you, Chief Justice, I agree with that. May I just add this, Chief Justice, even if the applicant is wrong in agreeing with that contention, then the only possible further issue that could arise from the perspective of the applicant wishing to finalize the institution of the application is, of course, to take relevant steps and ask the sheriff to cause service thereof to be effected. And even that was done, and those actions were performed timelessly on behalf of the applicant, i.e. on 21 September 2018 already. But the problematic aspect is, of course, that it has been explained, but very briefly so, that service could not be effected by the sheriff for the reasons stated in the affidavits of record in the court of first instance proceedings.
Yes, of course, you don't have to explain that if you are right in saying the meaning of institution of proceedings in the context of motion proceedings is the delivery of motion papers to the registrar and getting the registrar registering the case, so to speak, putting their stamp and giving you a case number. So if that is what you say is the meaning of institution of proceedings in the context of motion proceedings, you don't have to talk about efforts to have to contact the respondent, isn't it?
May it please you, I agree with that, Chief Justice.
Yes. Yes. Okay, we are at 11:30. I don't know if there are still colleagues who have questions.
Yes, Chief Justice, I have a few questions, but they're not going to be brief. I've got quite a few, so I don't know if you want to take an adjournment at this stage.
Okay, all right. Let's take the tea adjournment then. It's 11:30 now. We will resume at 11:45. We
Chief
adjourn.
Justice, if I just may indicate, if I may indicate, I also have a few questions which I will pose after Justice Van Zyl when we return.
Okay, all right. Thank you. Let's adjourn then. Court adjourns.
Court will adjourn until 11:45. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with the video and sound when the hearing recommences at 11:45. Should you exit, you may use the same link to rejoin the hearing.
Are we all back, colleagues?
Chief Justice, Justices of the Constitutional Court, all counsel are online.
Thank you. I think it was Justice Van Zyl who wished to put some questions to Mr. Swanepoel.
Yes, thank you, Chief Justice. Good morning, Mr. Swanepoel.
Good morning, Justice Van Zyl.
I have a few questions. You make a submission that the SCA, in dealing with the time limitation in Section 7.1 of PAJA, dealt with an issue that was not before it. As I understand your argument to be, that is based on the fact that it was never raised as an issue by the respondent in its answering affidavits. However, upon a reading of the judgment of the High Court, it would appear...
I'm sorry, Justice Van Zyl. Is Justice Theron in? Oh, there she is. There she is. Okay, all right. Thank you.
I think let me repeat the question.
I think start afresh, yeah.
Thank you. Mr. Swanepoel, you make the submission that the SCA, in dealing with the time limitation in Section 7.1 of PAJA, dealt with an issue that was not before it. And from your argument, it appears that that submission is based on the fact that the respondent didn't raise this as an issue in its answering affidavits. However, if one have regard to the judgment of the High Court, the court dealt with that issue and of course made the finding which it did on that aspect. Was the appropriate time not when that issue was raised in the High Court? Was that not the appropriate time for you to raise an objection to the issue being raised without it having been raised on the papers? And if that is so, and the matter was dealt with by the High Court, did the issue not become a live issue, which was then became part of the grounds of appeal of the respondent to the SCA, and which the SCA then ultimately dealt with?
Justice Van Zyl, as I understand the position and what occurred in the court of first instance in the High Court, firstly, yes, in the answering affidavit, the point wasn't raised. And secondly, if one has regard to the manner in which the time barring provision was indeed raised on behalf of the respondent in the High Court, was A, with reference to the November 2016 decision, and B, with reference to the decision date of 6 December 2017, and it was not raised to the best of my knowledge on behalf of the respondent, either in argument or in its answering affidavit in the court of first instance, that indeed calculated from the date of 26 March 2018, the time bar provision was also transgressed.
The second aspect relates to the merits of the or you being successful in the merits with regard to obtaining a refund. Do you accept that the applicant's case on that aspect hinges on two aspects, namely the first, the reissuing of the invoices in order to bring the claim for a refund within the time limit requirements of Part 1 of the regulations, and two, that the vendor incorrectly levied tax at the zero rate as envisaged in Regulation 6.6b. Do you accept that to be the position?
Yes, Justice Van Zyl, we indeed submit that those are the relevant considerations. Firstly, what we say is that the fact that replacement invoices, new tax invoices were issued, does not, upon a reading of the legislative provisions contained in the Value Added Tax Act or in the subordinate provisions, the export regulations, does not limit the ability of the recipient of the goods, that is Sasol Chevron. My apologies, Justices. We are just experiencing load shedding at the moment. I hope and trust that I'm still audible and visible on your side.
Yes, you are. Yes.
Thank you, Justices. Justice Van Zyl, so what we say is that the so-called election argument raised on behalf of the respondent, namely that the new tax invoices did not have the effect that the applicant in its position as qualifying purchaser could resort under the provisions of Regulation 6.6, that cannot be correct. No reasonable interpretation of the legislation or the subordinate provisions, the export regulations, justify such an interpretation and that contention. And indeed, insofar as it concerns the incorrect levying of tax on a zero-rated basis, one notes from the exchange of correspondence between the applicant's attorneys and the SARS officials, which preceded the 6 December 2017 impugned administrative decision, that indeed the respondent informed the applicant's attorneys that Sasol Catalyst, who was also represented by the same attorneys in almost all the correspondence, ought not to zero rate. You must go forth and standard rate the supply that you made. So in those circumstances, it's not open for the respondent to suggest that there was not an incorrect zero rating. Of course, the zero rating was incorrect. At the very least, it was incorrect because the exportation did not occur in time. And thereafter, credit notes and replacement tax invoices were issued, which were never impugned by the respondent, and pursuant to those, the value-added tax was paid by the qualifying purchaser, the applicant.
You make the submission in that it was on the advice of SARS, the respondent, that the original invoices, that's the invoices of August and September, were cancelled and then substituted. The portion in the letter, it's on page 35 of volume 2, paragraph 3, which you rely upon, does that in fact bear out that submission? And is there an allegation, and there appears to be no allegation to that effect in the applicant's founding affidavit, which is that they may have placed SARS in a position to deal therewith.
Yes, Justice Van Zyl, there is an allegation in the founding papers, indeed, that that the applicant was advised by the applicant, by the respondent to do so. If I may, just before I go to the founding affidavit itself, refer to page 107 in volume 2. There in the correspondence of 12 February 2018 in paragraph 3.
Yes, that's a paragraph I'm referring to. Does that paragraph bear out the submission that you're making, that SARS gave that advice to the applicant?
Definitely. Definitely. And the allegation is contained in the founding papers as well. And I'll reference the page in a moment, that the respondent advised the respondent to zero rate. And this is done in volume 1 on page 11, paragraph 11.3.
Sorry, just give me the page number again.
Justice, if you can just give me a second, I'll find it in a moment. At page 15, paragraph 12.10. Of the founding affidavit in the court of first instance proceedings, it provides that SARS indicated in the manner and at the time referred to below that Sasol Catalyst is required to levy and account for VAT at the standard rate. May I just, in addition to your question, Justice Van Zyl, add that, of course, all of this occurred, and this was not denied in the answering affidavit, but the context thereof is very important, namely that the qualifying purchaser, the recipient of the goods, the applicant in this application, which asked or requested an extension only of a time period, which did not submit a claim for a refund, had nothing to do with this process. It was not the dominus entity insofar as the decision to raise new tax invoices is concerned, but indeed in the founding affidavit, this was already stated.
So that submission, as I take it, is then based on paragraph 12.10 of the founding affidavit on page 15 and on page 35 of the paper's paragraph 3 of the letter, which appears on that page. Is that correct?
May it please you, Justice Van Zyl.
Thank you. The next question is, does the Act itself provide for the reissuing of an invoice?
It does, Justice Van Zyl. It is provided in section 21.
Where do you find that?
Justice, I do not think that section 21 is part of the record of the proceedings, but section 21(1)(c) is referenced in the founding affidavit, page 11, paragraph 11.3. The text of the section itself is not contained in the record of proceedings. I beg your pardon, it's section 21(1)(c). And that subsection on which the applicant in its founding papers stated that it provides as follows under the heading credit and debit notes. This section shall apply where, in relation to the supply of goods or services by any registered vendor, and then I jump to sub C, Justice Van Zyl, the previously agreed consideration for that supply has been altered by agreement with the recipient, whether due to the offer of a discount or for any other reason. And I've already made the submission that those were the only extant tax invoices after 30 June 2015. May it please you, Justice Van Zyl.
Thank you. You submit that if the proviso in section 11(1)(a)(2) is triggered, then different consequences follow therefrom. What I want to know from you is, how is the proviso triggered? Is it the payment of VAT by the purchaser, as that seems to be your contention in this matter, or is it the supply of the goods by the purchaser otherwise than at a zero rate, or by the vendor, otherwise than at a zero rate as contemplated in part 2 of the regulations, taking into consideration that in terms of sections 7 and 9 of the Act, the supply is deemed to have taken place on the date of the invoice.
Yes, Justice Van Zyl.
Taxes levied at the time of supply. In the time of supply, as I read the provisions of the Act, it's my reading, is the time when the invoice is issued.
Justice Van Zyl, a few considerations find application in relation to your question. Section 7 is, of course, the triggering provision contained in the VAT Act. It provides expressly that value-added tax must be paid in respect of a supply, but it is not a blanket provision that always applies. It immediately, in the beginning part of the wording of subsection 1, provides that subject to the exemptions, exceptions, deductions, and adjustments, Value-Added Tax Act must be levied. And then zero rating is provided in section 11(1)(a). And indeed, Justice Van Zyl, you correctly put your finger on the provisos there. And your question, as I understand it, is what triggers the proviso to find application? And we submit with respect, it is to be found in proviso AA of section 11(1)(a), which provides, where the wording or the text provides as follows: where a supplier has supplied the goods to the recipient in the Republic otherwise than in terms of this subparagraph. That is the triggering of the proviso itself, i.e., as you've stated as part of your question directed to me, Justice Van Zyl, it is the provision of the goods or the supply thereof otherwise than by zero rating. And that occurred, of course, pursuant to the credit notes and the new tax invoices.
But if the supply is deemed to have taken place at the issuing of invoice, and that invoice was then at a zero rate, how does that affect matters?
Yes, the time of supply rules, Justice Van Zyl, is contained in section 9 and its subsections of the Value-Added Tax Act. And of course here, At the time when the zero-rated tax invoices were issued, i.e. in the circumstances of this present case, in August and September 2014, those are the tax invoices under consideration. That would have been the supply. But pursuant to the credit notes and the issuing of the new or replacement tax invoices, there would be a change in the time of supply, bearing in mind that the Commissioner did not say a time of supply rule finds application, and for some or other reason, one has to resort to non-existent zero-rated tax invoices. Bearing in mind, secondly, that the Commissioner did not impugn the new tax invoices, and bearing in mind, thirdly, that this applicant, who is the paying recipient and qualifying purchaser of the movable goods, can in no circumstances claim the VAT refund based on zero-rated tax invoices. It needs to be in possession of a standard rated tax invoice. And back then at the time, that was levied at the rate of 14%, not 15% as it became later. May it please you, Justice Vincent.
Thank you. I think you have provided a reason why you say that the zero rating of the supply was incorrect. But I want to refer you to paragraph 113 of your submissions. And do I understand the argument there to be that zero rating is done erroneously as contemplated in Regulation 66B when the goods are not exported within the required 90-day period? How does that render the zero rating to be erroneous? I don't follow that.
Yes. Well, Justice, there can be no zero rating, and this is what the regulations provide if the exportation did not occur in time. The regulations state so expressly. If you cannot zero rate if you don't export within 90 days, and that is indeed the reason why it is submitted that it was erroneously levied at the rate of 0%.
Why is that an error as contemplated in 66B regulation?
Well, if one reads 66B, Justice Van Zyl, what one sees there is that the subordinate provisions provide in section 66 that the Commissioner may extend the period within which a qualifying purchaser may submit an application for a refund of tax where the Commissioner is satisfied that, and then subparagraph B, a vendor, which is Sasol Catalyst in the context of the facts that are under consideration, incorrectly levied tax at the zero rate on a supply of movable goods to a qualifying purchaser. And of course, the levying of tax at a zero rate may not, at the time when the issuing of the zero-rated tax invoice occurs, i.e. August and September 2014, qualify as being incorrect, but it became incorrect because the exportation did not occur within the prescribed time period. That is exactly what the export regulations provide. So one has to ask the question, we submit respectfully, when did it become incorrect? And we respectfully submit that the answer can only be after it emanated that exportation did not occur in time. Then provision is expressly made for a standard rating, and provision is further. I beg your pardon, Justice.
Proceed.
Thank you, Justice Van Zyl. And provision is further made for that qualifying purchaser recipient to then pay the VAT and to claim back. Of course, Justice Van Zyl, one must also identify those parts of the regulations which provide that if the exportation does not occur in time, the supplying vendor becomes liable to pay the VAT. But that has no bearing on the applicant with its hat on as qualifying purchaser, and with its hat on as qualifying purchaser pursuant to the new tax invoices being issued by the supplier Sasol Catalyst. Therefore, we say the respondent was mistaken in continuing to consider the content and dates of the original zero-rated tax invoices. The extent tax invoices at the time when the request for extension was made were the new tax invoices, and the old ones ceased in law to exist.
Yes, that may be so, but you have asked for an extension of the time period within which to lodge a claim for a refund, and that was refused. So you have to have that decision set aside, and that can only be set aside on the basis of you showing that the zero rating was done in error. So it's important to establish whether or not an error did occur, as envisaged in Regulation 66B, is it not?
Yes, Justice Van Zyl, as I understand decisions of this court, such as the one in All Pay, it would be incorrect for the administrative decision maker to say there are two processes to be followed. Step one is, I'm now busy considering a request for an extension of a time period. That particular decision maker would not be the decision maker in respect of step two. It would be the VAT refund administrator, another by statute designated decision maker. But instead of granting the extension, I deem it prudent to say, as the commissioner, because I think you will never be able to obtain the VAT refund, I say no to the extension that you request. That's the first response to your question. And the second response is, it is not in law necessary for an applicant seeking an extension that is permitted to be granted only by the commissioner pursuant to the provisions of Regulation 15 of the export regulations to say, kindly give me extension of the time period within which to request the refund. I don't ask for the refund now, and I can't even ask it from you. I must direct my request to the VRA, the VAT refund administrator. And if the response is then, well, I think you can't get what you want to ultimately ask from somebody else, therefore I say no now, we say such an interpretation of the relevant subordinate legislation would be constitutionally unacceptable in these circumstances. So our submission is that it's not necessary at the time when you request the extension to also already make it clear that you qualify for the refund that is not yet under consideration.
But do you accept that if it were to be found that the supply of the goods were not incorrectly zero rated on the basis on which you rely, that would be the end of the matter without the necessity for this court to delve into the question whether the construction which Sasol seeks to place on the regulations and the Act is incorrect?
Yes, Justice. If that is the finding, Justice Van Zyl, that is to be that is made by this court, of course, it would then put an end to the whole process of the application for leave and appeal itself. But that question must be considered in, as I've already argued a short while ago, that the new tax invoices were absolutely never impugned, and they came about on the version of the applicant, which was also not disputed in the affidavits of record in the court of first instance, that an error occurred on the advice of the respondent. The applicant issued credit notes and new tax invoices, and the VAT were paid pursuant thereto. At no stage in the quota quo proceedings did the respondent assert that no error occurred. Yes, it did in its current heads of argument make the submissions that this was not by error, it was deliberate, it was intentional, etc., but it can never deny the fact that the zero rating as it occurred pursuant to the August and September 2014 tax invoices was incorrect. Why? Because exportation only occurred after the relevant period. And if one interprets the regulations to mean that those are subordinate legislative provisions assisting the national legislation by Parliament, the Value Added Tax Act, to ensure that only a supply of goods, movable goods in these instances, or in this instance, is met with the value added tax liability. If local consumption occurs, which in this case did not occur, then such an interpretation, of course, is sensible in the circumstances. The so-called risk that the respondent refers to in its heads of argument, to the effect that the supply initially made is made by the vendor supplier, Sasol Catalyst, at the risk of potential non-compliance, and that it would then become liable to pay the VAT. To an extent, there may be truth in it, but it disregards the subsequent credit notes and the new tax invoices and the fact that VAT was paid. And lastly, the fact that Regulation 66 allows for that refund to be claimed.
Mr. Sonnepoel, I'm going to appeal to you to do your best to give succinct answers, not be too elaborate. Okay, all right. Thank you.
Thank you. I
Are
have
you
nothing
done?
further, Chief Justice.
Yes, Justice Theron, but before you do that, before you ask your first question, Justice Theron, Mr. Sonnepoel, I may have misunderstood you and your written submissions, but I thought you make some point that the Supreme Court of Appeal raised the issue of non-compliance with the 180 days requirement meromotu, but I see that the commissioner in the answering affidavit in the High Court did take the point. Did I misunderstand you?
No, Chief Justice. Indeed, the non-compliance with the 180-day time period prescribed in Section 7.1 was taken by the respondent in the quo answering affidavit, but on the following two bases only. Firstly, it asserted that the relevant decision date was November 2016. It later on conceded on appeal that for purposes of the appeal, December 2017 was indeed the correct date. Secondly, in the quo answering affidavit, the respondent said, even if the 6th December decision is taken as the operative date for commencement of the 180-day period, then it was out of time. What it did not do is seek to also allege that the date on which the reasons were given by the respondent pursuant to the request made to the respondent in February 2018, if that is the date for purposes of commencement of the calculation of the 180-day period, that then also the application was made out of time. So we persist respectfully, Chief Justice, in our submission that that point was indeed raised mero motu by the Supreme Court of Appeal.
Okay, all right. Thank you. Justice Theron. Justice Theron? Oh, is she frozen? Can you hear me, Justice Theron?
What is your submission? Yes, I can hear you, Chief Justice.
Oh, okay. I couldn't hear you before, so you may have to start afresh.
Yes. We're experiencing load shedding as well as a power outage, Chief Justice.
Yes, okay.
Mr. Sonnepoel, yes.
Justice Theron.
What are the submissions of the app? What are the submissions of the applicants?
My apologies, Chief Justice.
In respect of what this court must do in relation to the decision made by the Supreme Court of Appeal of the 180-day time limit.
Justice Tron, if I understand your question correctly, and I could only hear intermittently, there was a breakup in the audio from your side, for which I apologize insofar as it might be our fault. But if I understand your question,
I'm going to switch my video off. Maybe, what are your submissions? Yes, Mr. Sonnepoel?
I'm not sure if he had the question. Maybe you might have just to repeat the question, Justice Theron.
Yes. What are your submissions in relation to what this court must do about the Supreme Court of Appeal's decision relating to the 180 days?
We submit two things, Justice Tron. Firstly, the correct commencement date must be the date of the reasons provided on 26 March 2018, because the respondent never argued that reasons had been provided earlier. And secondly, we submit with respect that the directive given by this court in the judgment of Camps Bay Ratepayers Association was not adhered to with respect by the Supreme Court of Appeal in its judgment in circumstances where it, mero moto, raised that particular non-compliance. And secondly, that the fact that service of the application indeed occurred on Tuesday.
I'm sorry to interrupt you, Mr. Swanepoel. I'm sorry. I know you have filed the other two reasons. But my question is centered around the reasons, the date of the decision and the date of the reasons. Now, if I understood you, you're saying, Mr. Swanepoel?
Yes, Justice Tron, I can hear you.
Yes, yes.
It does look like there is a serious problem from Justice Tron's side.
Yes, you said that the Supreme Court of Appeal.
No, it's not working, Justice Tron. Maybe let us do this. Hopefully your situation will improve. Let me check whether there is any other colleague who still has a question. So maybe they can put their questions if there is anybody. And then we will see after that whether your network or whatever has improved. And then you will still get a chance.
Thank you, Chief Justice.
Yes. It doesn't look like, is there any other colleague who still had a question? It doesn't look like there is any. Maybe give it a try again, Justice Tron. If we don't get it right this time, or if it doesn't come right, then my suggestion is that we move to hear Respondent's counsel, and when Mr. Swanepoel replies, hopefully your situation will have improved, and then I'll give you another chance to put your questions at that stage. Is that fine?
Yes, thank you, Chief Justice. Thank you. It looks like power has been restored. I'm going to change to a different Wi-Fi, Chief Justice. Maybe that would help.
Oh, okay, all right. Are you suggesting that we give you that chance before?
I'm on a different connection. I hope this might be better, Chief Justice.
Okay, give it a try then.
Yes. Mr. Swanepoel, you said that the reason was because the respondent didn't say that the reasons were granted earlier. And on that basis, the Supreme Court of Appeal should not have decided when the reasons were granted. Isn't it a question of fact to be determined from the record as to the date when the reasons were granted? Does it matter what the respondent says about, if the respondent is silent about when the reasons were granted, can't this court or the ACA or the trial court make a decision as to when the reasons were granted for the purposes of determining the 180-day period?
Firstly, Justice Tron, yes, it is a question of fact, but it is a question of fact that was not put in dispute in the court or quo proceedings. You are, of course, correct, because Justice Tron, this court held unanimously in the matter of Camps Bay Ratepayers Association in paragraph 57 of the judgment authored by Justice Brandt, that indeed the question when the administrative action was taken is something that is a question of a factual nature. However, from the affidavit, the dispute of fact has to appear, firstly. Secondly, even if the respondent did attempt to deny that there was a necessity for the reasons, and that B, the reasons were just a repeat of what was previously stated, one sees from a reading of the reasons themselves that for the first time on 26 March 2018, something is proffered as a reason why not Sasol Catalyst can't do certain things or become entitled to an extension of the period to export the goods, but for the first time, something is said of substance as to why a request for extension cannot be granted. And this is to be found on page 112, paragraph 3.4. And of course, lastly, Justice Tron, even if it was a dispute of a factual nature raised in the quota quo, which it wasn't, it's not something that must appear from a reading of annexures, etc. The respondent ought to have said, listen, you asked reasons, you're not entitled to reasons, we gave reasons earlier. If one reads the 26 March 2018 reasons letter, it says, you asked for reasons, yeah, they are. And then it continues with substantive provision of the reasons. May it please you.
Justice Theron? I think she's gone.
I think we may have lost her, CJ.
Yes, maybe we have lost her. She will reconnect. She will reconnect. I think in the meantime, in the interest of time, we'll move on to hear the Respondents' Counsel. And when Mr. Swanepoel replies, I'll give Justice Theron an opportunity to ask other questions that she may have wanted. I see she's back. Yeah. Justice Theron, can
yes,
you hear me? Okay. I was about
to
move
you,
to
Justice, here.
I was about to move to the Respondents' Counsel, but since you are back, you may continue if you still have further questions.
I'm going to try to be very brief. Mr. Swanepoel, my concern is not what the content of the reasons was in respect. I think the letter of December sets out paragraphs 1, 2, and 3, which Justice Majid referred to. Then the letter of March adds paragraphs 4, 5.
Oh, we have lost her again, or she's frozen. Justice Theron, we lost you again. Okay, I think we'll move to the Respondents' Counsel. I'll give her a chance later when Mr. Swanepoel replies. I think let's move to Respondents' Counsel, Justice Theron. When Mr. Swanepoel replies, I'll give you a chance to ask whatever other questions you may have had. Okay.
As the court pleases.
Yes. Thank you.
Chief Justice, members of the court, in our submissions, we will refer separately to the applicant as Chevron and to the counterparty, who was the South African Sasol company, who was the seller in the transaction, as Catalyst. We will deal with the topics that have already arisen during the course of our learned friends' arguments, which is the time from which to commence calculating the 180 days, the date on which the 180 days stopped running, and then issues relating to merits. So we start with the determination of the commencement date. And in that regard, there are three scenarios. There's the decision and reasons given on the 7th of November, 2016. Now, there was no concession made that that's irrelevant. For the purposes of the argument before the SCA, we stuck to the 6th of December because it made no difference. But it's important, it gives rise to important contextual information in having regard to the reasons that were given and the decision that was conveyed. Then there's the 6th of December 2017 decision, and finally the so-called reasons of the 26th of March 2018. To determine the commencement date, it's of course critical, and we understand that despite what our learned friends submitted in their heads, that it's the day on which reasons are given for a decision if they're not given on the same day. Reasons were given on the 7th of November 2016 and the 6th of December 2017. There is no issue of adequacy of reasons raised on the papers or in the argument. There were simple reasons given, and I'll take the court to those in a moment. Of course, as to the extent that adequacy does enter into the picture, we've dealt with that in our heads of argument at paragraph 23 and following. And there is, of course, this court's judgment in Koyabi, which mirrors the test for reasons that's stated fairly frequently, and a with respect, clear way of putting the requirement is expressed in Koyabi as ordinarily reasons will be adequate if a complainant can make out a reasonably substantial case for review. That is a benchmark test for adequacy of reasonableness, and that's mirrored in Hoekster's work at page 646, where there's a quotation from Curry's work as well. But that the reasons given on the 7th of November 2016 and the 6th of December 2017 were sufficient for the purpose of bringing an application is, in our submission, illustrated by the fact that Chevron was able to bring its review application despite the fact, as has been pointed out in interactions with our learned friend, despite the fact that the reasons of the 26th of March 2018 added nothing to what had already been said. The recipient of the ruling of the 7th of November 2016 and December 2017, Dr. Bardnos, explains in his application to this court for leave to appeal that he is an expert, highly proficient in matters relating to value-added tax and taxation in general. That is a relevant consideration, as Hoekster also points out on page 464, in considering adequacy of reasons. And again, I repeat, there is no quibble about the adequacy of the reasons that were given in November and December. Then determining the date of the, I beg your pardon, let me come back to that. The three scenarios. The 7th of November letter is a little bit more than that. It's at page 89. It is a ruling issued under section 41B of the VAT Act, a written binding ruling, binds SARS. In the request for the ruling, which is the 6th of July letter at page 59, and this has been touched on already in exchanges. In that request, at paragraph 6 and at paragraph 10, particularly 10, the request is that you grant an extension to Chevron in terms of regulation 66B to submit a claim for a refund to the VRA. That is the request. It is expressed conditionally, that is so, but that is the request that was formulated. The answer to that is in the letter of the 7th of November, and in the usual fashion that you will have come to recognize, the request is set out in the initial portion on page 89. I beg pardon, the background on 89. The request is summarized on page 90. The only subparagraph of that the only request contained in this letter relevant to Chevron, the applicant in this matter, is that in 2.3. And it is accurately summarized as being, can Chevron have an extension in terms of regulation 66B to submit a claim for a refund? Now, Justice Van Zyl has dealt with the issue of whether 66B applies or not, and with respect, we submit in response to the questions posed to our learned friend, it does not apply because there was no error. There was no mistake here. It was a deliberate act of seeking to zero rate a supply, which, of course, Catalyst was entitled to do, subject to the provisions of the regulations. Then in paragraph 4.9, and with respect, I'm picking out bits and pieces, but one must read the letter as a whole in context to understand its import. But 4.9 says, in terms of regulation 61A, that should be 66A, the VRA is, in terms of section 449, authorized to make a refund of tax to a qualifying purchaser where the VRA is satisfied that the qualifying purchaser has, amongst others, fulfilled all the responsibilities set out in regulation 3, and that's where the reference to the 90 days within which to export is referred to. The decision in relation to Chevron's application for an extension of time within which to apply to the VRA is dealt with in paragraph 5.4. And it says no extension is granted, that is the decision, in terms of regulation 66B of the period within which to application may be made for a refund. And here's the reason. As the goods were not exported from the Republic within 90 days from the date of the tax invoices. Now that is an intimation by one specialist to another specialist of a reason for a relatively straightforward decision. That is administrative action with reasons. The second, it's obviously not left there, and we move to volume 2. And at page 105, this, as has been made clear by our learned friends, is the decision, the impugned decision dealt with. It refers on page 105 in the introductory passage to the previous correspondence, including the ruling of the 7th of November and the subsequent letter of the 6th of July in which Chevron's application was made, and a further letter dated the 18th of October. Now, there's an argument in their heads that you must ignore the previous letters because they weren't incorporated by reference. Well, they were incorporated by reference. Here they are. And in paragraph 4 of the letter on page 102, which is the request, it's recorded that Sasol Catalyst applied on the 6th of July for confirmation that should SARS still remain of the view that it is required to account for output tax on the invoices issued, that Chevron is granted an extension. So it's a repeat of the same request. It is the only request in this letter of the 18th of October, 2018, that relates to the applicant in this matter, Chevron. It's the only request. That is then dealt with in the paragraphs of the letter of the 6th of December to which reference has already been made. And there in paragraph 4, Chevron's application is dealt with. and it says that Chevron is not entitled to a refund of the VAT. Now, that isn't the question that was asked. The question was asked whether they could obtain an extension of time within which to apply to the VRA. But that was clearly understood to be what was meant. So in this letter as well, a decision is communicated in relation to Chevron, and reasons are given in 1 to 3 for that conclusion. So what then happened is a further application for reasons was then made on the 12th of February 2018. There's a somewhat mischievous suggestion that SARS spent 3 weeks writing the 6 weeks writing the response, but 6 weeks later it did respond. And essentially the same question is repeated, the same application is made, and it's clear from page 108, paragraph 4 and 5, that SARS reached the conclusion that the Chevron was not entitled to a VAT refund on the basis that Catalyst had originally elected to export the goods in terms of part 2 and now wanted to change to part 1. That's clear in paragraph 5 and 6, which says on that basis, SARS has denied Catalyst's application. And then in the so-called reasons that were given on the 26th of March, may I go back to one issue that was raised in argument. Paragraph 7 on page 108. The statement is made that SARS has not provided any reasons for its decision and its interpretation. Well, that's wrong on the analysis of our recent submission. The reasons were in fact given. But in order to contrive a situation where yet further reasons were given to allow the 180 days to start running afresh, the allegations made there's no reasons, and a request for reasons is once more made, and it's responded to in the letter on page 110. And the request is repeated in paragraph 2.1 on page 111. Explain why SARS considers that the qualifying purchaser, which is Chevron, is precluded from claiming a refund under section 44.9 as provided for and so and so. That is a question that has already been answered. Then we go to the reasons, and the reasons deal with Sasol Catalyst in 3.1 on page 112, 3.2, 3.3. These are tangentially relevant to Sasol Chevron as well, but there's no additional reason given in paragraph 3 for the decision made not to extend the time within which to apply for VAT refund from the VRA. So we submit that the difficulty that arises from this letter, the 26th of March letter, for Chevron, which it submits, gives the final reasons that enabled it to bring the application, is that it adds nothing to what was already said. So if they are able to bring their application on the basis of the 26th of March letter, they were able to do so on the basis of the combined effect of the 7th of November and 6th of December letters, and they were able to do so on the basis of the 7th of November letter on its own. The reasons set out on page 112 relate principally to the merits argument, to which we will briefly come in due course. But we submit that the decision and the reasons for the decision were given either on the 7th of November 2016 or the 6th of December 2017, and that the 180 days started running from either of those two dates. And as we said to the Supreme Court of Appeal, for us it doesn't matter which, because on both scenarios the 180 days had elapsed well before the application was given. So then we came to the High Court, and the matter was argued there on the basis that the delay point had been raised in the answering affidavit squarely. It was raised on the basis that the decision and reasons were given on the 7th of November or the 6th of December, but it was raised squarely. And that fact distinguishes it from other authority dealing with a situation where no delay point is ever raised. But even if delay point is not raised, and despite the authority relied upon by our learned friends, we would submit that the question of whether or not a PAJA application is properly brought under Section 7.1 of PAJA is a matter of law, and it applies irrespective of a failure by a respondent to raise it. That was the conclusion to which the court came in New Adventure Shelf versus SARS, which is a 2016 All South Africa report at page 179. It's a judgment of the Western Cape High Court, so it doesn't bear the status of judgments of this court, but the reasoning we submit is at the very least useful. This is also not a case of impossibility. So one of the arguments that's put up by our learned friends in their heads of argument relates to the Penglides case, which they annexed to a supplementary note that they put in. Now, Penglides dealt with a situation, their relatively short time period of 30 days, where a party was given 30 days within which to do something. The fact that the 30th day fell on a Saturday when the offices of the relevant authority were closed meant it was objectively impossible to serve on that day. So the court said that to interpret the requirement to give only 29 days to the party would be depriving them of rights that had been given to them. So you had to allow them until the following business day to deliver the notice. Now, the 21st, the day on which the papers were stamped by the registrar at the High Court, was a business day. There is no evidence, no admissible evidence, despite our learned friends' attempts to elevate our complaint about the hearsay nature of what is submitted in the affidavits placed before this court in the application for leave to appeal as inadmissible hearsay. They say it's common cause that it was impossible to serve. It's not common cause. There's no evidence of any admissible nature before this court or before any other prior court that it was impossible to serve on that day. We don't have a sheriff's return. We don't have an affidavit from the sheriff. We don't even have a hearsay affidavit from the corresponding attorney. We have a statement that the current attorney understands from his correspondence that this may have been the position. So with respect, there's nothing to show the kind of impossibility that's dealt with in Penglides and the English cases on which reliance was placed in that judgment, and the judgment is entirely distinguishable. The requirement, of course, is to institute proceedings as soon as reasonably possible, but by no later than 180 days. And that issue was dealt with by the Supreme Court of Appeal in the following circumstances. There was no allegation in the founding affidavit that Section 7.1 had been complied with. It may be regarded as a jurisdictional fact in an application of this nature that requires to be pleaded. But whatever the position, it wasn't raised at all. The decision was identified as that of the 6th of December. During the course of argument before the High Court, the submission was made that the date on which the 180 days commenced was the 23rd of March. I can't, and I don't pretend to remember precisely what happened in the High Court, whether that was from the bench or from our learned friends, I simply cannot say. But it was raised squarely. And in the judgment of the High Court, that is the basis upon which the court found that 7.1 had been complied with, that what was required was the issue of papers by the registrar, the stamping of the notice of motion by the registrar and the allocating of a case number. That finding was not a finding that was raised, well, that was not predicated on anything that was said in the papers. But in the application for leave to appeal to the SCA, it was squarely raised by SARS. SARS said that one of the grounds on which the High Court erred was the fact that it had incorrectly determined the state. And reliance was placed on ABM Motors, which in turn relied on the SCA judgment in Pambili Fisheries.
You have 5 minutes left.
Thank you, Chief Justice.
Thank you.
And ultimately, our submission on that, or the court found, in ABM Motors, which was based on the SCA judgment, the court found you need to serve, and for the obvious reasons that are set out in that judgment. And they are attempted to be dealt with by learned friends in their heads of argument on the basis that the sheriff is independent and must do the bidding of the parties as an officer of the court. But the position is an attorney goes, or a clerk goes to the registrar, has the document stamped, and then takes that to the sheriff. And whether there's a 6-month delay or a 1-year delay between the date of issue, to use that expression, and handing it to the sheriff has got nothing to do with the sheriff. It's not in the sheriff's hands when to serve. In that sense, a delay can be by negligence, by intention, by sheer inadvertence that can delay. And the purpose then is not served. The purpose being that the functionary, the decision maker, the administrator comes to learn of the review application within the 180-day period. We have dealt with, so with respect, it wasn't a question of the High Court raising anything meru motu. By the time we went to the SCA, this matter was front and center, this issue. And in any event, the delay having already been pleaded, it was open to the SCA to take what ultimately was a pure law point. It was on common cause facts. The letters are there for everyone to read, and it took a pure law point. Then on the question of the merits in the time available to me, I wish simply to make this submission. The law doesn't allow the retraction and reissue of invoices for the same supply. That's clearly stated in section 20 in brackets 1 in brackets Roman I, Roman 1. It is not lawful to issue more than one tax invoice for each taxable supply. Section 21(1)(c), which is relied upon, and these are issues of law, relied upon by Chevron, has as one of its requirements, or one of its the circumstances under which a credit note may be issued, the previously agreed consideration has been altered by agreement. That did not occur in this matter. If one has regard simply to an example of the old invoices at page 36 of volume 1, that's the first invoice, and compares it with its replacement at page 62, the consideration remains the same. The purchase price remains the same. All that is added is VAT. This is not what is contemplated by subsection C. What's contemplated by subsection C is a change in the price. There was no change in the price there. There was no double taxation issue raised on the papers or in argument before the previous courts. I think I've the fact that it is contended that the export was delayed for reasons beyond the control on the very thin grounds that have been put up in the correspondence. We said to be bound by those facts and not able to question them. Well, that can't be right, because all they're asking for is the opportunity to make those representations more fully in an application for an extension of time. We would submit ultimately that the application was brought out of time. The order of the SCA was in the circumstances entirely correct. The application for leave to appeal should be dismissed on the basis that there are no prospects of success, and therefore the interests of justice component of the test is not met. Alternatively, if leave is granted, that the appeal should be. Your time is up. Thank you, Chief Justice.
Thank you. We'll allow this opportunity for the justices if they've got questions. I think the Deputy Chief Justice, we lost her, but I think she's reconnecting.
I'm back, CJ.
You're back, thank you very much.
Yes, thank you.
If there are any questions from the colleagues, that's what we can deal with now. I don't see any indications.
Chief Justice, if I may.
Yes, yes, Justice Theron.
Thank you, Chief Justice. Mr. Shelter Douglas, on what basis is the contention made that the VAT regime, particularly the export regulations, should be interpreted so as to contemplate an irrevocable election? is this a textual, contextual, or purpose of grounding, and what supports the argument of the respondent?
Thank you, Justice Ron. The answer is purpose of contextual. The textual, right? Purpose of textual. The manifest purpose of the export regulations is to allow the export of goods free of VAT, while at the same time ensuring that these regulations are used for the purpose for which they are intended and they're not abused. To meet that aim, that anti-abuse aim, the Act and the regulations read together provide for a limitation on the right to export goods free of VAT. That limitation takes the form of an obligation to export the goods within a reasonable or within a specific time. A failure to do so renders the transaction VATable, and that's precisely what happened here. Then what you have from a textual point of view is you have Section 20 and Section 21 of the Act, which allow, firstly, Section 20 prevents multiple invoices for the same supply, and Section 21 gives limited circumstances where credit notes can be issued. There is nothing in the VAT Act that allows a vendor to reissue a VAT invoice for the same supply or issue a credit note in circumstances other than those dealt with in Section 21. And that feeds in to the Section 11(2) exception in relation to exports and the structure of the regulations. The regulations start with a choice. Do you want to export on a zero-rated basis or not? You can choose. Now you decide to export on a zero-rated basis. If you don't comply...
Why, I'm sorry to interrupt you, but why can't that choice be changed at a later stage?
Because once you've exported the goods under a particular regime, you can't undo that transaction. You cannot travel between the two. Well, firstly, you can't do it because you can't reissue the invoices. You cannot legally, lawfully do what Catalyst attempted to do in this case. What the Act says in those circumstances, and it's a very fair provision, it says what happens then is Catalyst, you've exported at the zero rate, now you must pay VAT. What VAT must you pay? You must pay VAT in terms of Section 64 of the Act, which means you must calculate the tax fraction on the purchase price that you've asked for. That means that Chevron becomes liable. Another part of what Chevron paid constitutes VAT, which can be refunded under the VRA scheme. So if everybody had done what they ought to have done in time, there would have been a netting off of liabilities. But ultimately at a lower consideration. And I don't know this, but a possible reason for issuing new invoices is to keep the consideration where it was.
Why should an election made by a vendor later prejudice the purchaser if the goods cannot be exported within the 90-day limit?
So with respect, it doesn't prejudice the purchaser. So Chevron sits in a situation where it still pays the same amount of money. In fact, it's benefited to the extent that it can now claim the tax portion of what it pays as a VAT refund. So it doesn't get prejudiced at all. What prejudices it in this case is its failure to bring its application to the VRA on the zero-rated invoices timelessly. It was late. It sought an extension that could only ever have related on the time period Justice Rogers took our learned friend through. That initial request for an extension of the time within which to apply for a VRA refund could only have related to the zero-rated invoices. But now it can't get those back because it's too late, can't get that VAT back. So the parties then enter into a different scheme, which is to unlawfully issue fresh invoices and then say, now we would like an extension of time within which to apply for a VRA for the standard rated invoices, which was wholly unnecessary if that was a good scheme, which it was not, with respect.
Thank you, Chief Justice. Thank you, Mr. Shelter Douglas.
Thank you, Justice.
Thank you very much.
If I may, just briefly, Mr. Shelter Douglas, just to get the timeline right, the standard rate invoices, the ones you say SARS, Catalyst was not entitled to issue, were issued on 30 June 2015. Is that correct?
That the original invoices,
the standard rate invoices.
Oh, the standard rate invoices, yes, quite correct. The first one was the 30th of June.
As far as I can see, up until the 7th of November 2016, which is SARS's first ruling, I think. Up to that date, and in that ruling itself, SARS had not been told about the issuing of the standard rate invoices. Is that correct?
That is correct. There's no suggestion that they were told.
So the reason that is provided in the November 2016 letter is based on simply on the goods weren't exported within 90 days from the only invoices of which SARS had been told up to that time, which was the zero invoices.
Precisely, Justice Rogers.
Yes. Then to follow it through, and correct me if there's an earlier date, according to my notes, the first occasion when SARS is told of the new invoices is in paragraph 10 of the further representations from Catalyst on 18 October 2017. And we find that in volume 2 of the record, paragraph 10 is at page 102. The original zero invoices were cancelled in terms of that section which you submit is inapplicable, and replacement tax invoice was issued. As far as I know, it just refers to a single invoice and no date is given, but that appears to me to be the first occasion when SARS is told that there are new standard rate invoices.
That is my understanding, Justice Rogers.
Would I be correct that in a situation where the recipient, Chevron, has only received zero invoices, there could be no question of a refund? It hasn't had to pay. It hasn't received an invoice in terms of which it has to pay that, so there can't be anything for which it can claim a refund.
In the ordinary course, Justice Rogers, but if the 90 days has expired and the VAT fraction must be applied to the purchase consideration, then they would, in our submission, be entitled to apply for a refund because effectively the transaction would have been rendered VATable.
I see, yes. Either way, so it's in October 2017 that SARS is first told of standard rate invoices. It's not told when they were issued. And then comes the ruling, the impugned decision of December 2017. And if I can just take you to volume 2, page 106, as you pointed out in your address, paragraph 4 is the only part of that letter which addresses the Chevron's refund extension request.
It does, but it starts with the words "as a result" and therefore must be read with the preceding paragraphs.
Yes, I wanted you to take you to that as a result.
Yes.
As I read the letter, the result is the result referred to in paragraph 3, Catalyst's
Correct.
election.
Yes, correct.
This doesn't this letter doesn't address the standard rate invoices or any implications which might flow from the fact that new invoices have come into existence.
No. So all along, the request remains the same. Give me more time to make an application to the VRA for a refund.
And that might, as you've now pointed out to me, that might either be because if an export extension is given, if the tax fraction becomes applicable because the goods aren't exported within 90 days, then surely I'm going back to the previous answer, that still wouldn't require Chevron to claim a tax refund, would it? Because the party that has to account for that VAT out of the total consideration is the supplier, Catalyst.
So this may be an over-generous interpretation of the facts, but certainly the consequence of a delay in export is that Catalyst must pay that in terms of Section 64 and Regulation 16.3 on the consideration to SARS. So it now becomes vatable
on the amount in the zero invoices. So say the price in the zero invoices was 100, then it now has to, Catalyst, the supplier, not Chevron, the recipient, has to pay 14% of 100 to SARS. So it only gets a lesser net amount in its pocket.
That's correct. But remember, these are at least...
Sorry, and there's nothing in the legislation which then says that somehow gets passed on to Chevron. On the contrary, I understood SARS's position to be that in those circumstances, Chevron still just pays the 100 it was always intended to pay, and the person who benefits from or who suffers from the fact that the requirements for a zero rating were in the event not fulfilled is the supplier, Catalyst.
So my understanding was that the intention of Chevron was to apply for a refund of the VAT that Catalyst had paid to SARS on the 100. Whether it was entitled to do so or not has never arisen in this matter, but that is the reason why it wanted an extension of time to apply to the VRA. But perhaps it's not on the papers as to why they wanted an extension of time. And that's the only reason that I can think of.
Well, possibly Mr. Swanepoel can explain this in reply, but I, for the life of me, don't see how a party who hasn't had to pay any VAT can claim a refund. The only purpose for Chevron to claim a refund would be to give it back to Catalyst, which had in the meanwhile had to give up 14% of its consideration.
Yes.
It just doesn't seem to make sense to me. But either way, the position as at December 2017, SARS at last did now know about the standard rate invoices. But it's the reason in paragraph 4 of the decision letter is simply Catalyst made an election, and it follows that part 1 just doesn't come into play for anybody.
Yes.
And if we then go to the reasons at the further document in March 2018 at page 100, and as you say, the reasons are in paragraph 3. Am I right that this reasons letter doesn't refer anywhere to the replacement invoices or attach any significance to them?
It does not, Justice Rogers.
It doesn't offer any reasoning in relation to how the issuing of new replacement invoices might have changed the landscape.
No, Justice Rogers.
And the reasons given in paragraph 3 are all to do with Catalyst's election.
Yes.
Yes. I just wanted to be sure that I hadn't misunderstood anything. If there is anything in that reasons document which references the standard rate invoices, you can perhaps draw to our attention, or Mr. Swanepoel will, because it then seems to me that the essence of the argument, which is now advanced by Chevron on the merits of the VAT case, is entirely focused on the fact that there were new invoices. for better or for worse, the zero invoices on its version no longer exist. And it's all to do with the standard rate invoices. But it doesn't seem to me either in the decision letter of December 2017 or in the reasons of March 2018 that that argument, I don't know how fully it was put up in the request for reasons, but either way, it's not addressed in the reasons, and then followed the review application.
May I just add one thing, Justice Rogers? If one has regard to the notice of motion, and in paragraph 2, which is the declaratory order sought initially, that relates to the invoices of the 20th of August and the 22nd of September. And if I can just find the...
Yes, I do see it.
Yes, and those, of course, the old invoices, which on Chevron's or Catalyst's position no longer exist, as you pointed out, Justice Rogers.
And am I right that in the argument on the merits of the VAT point, despite the formulation of paragraph 2, and one doesn't necessarily wish to be overly technical about the framing of the notice of motion, one will look at what the affidavit was and all the arguments were. But the argument from beginning to end in the High Court on the refund point and on the extension for a refund, it hinges entirely on these replacement invoices.
Yes, that would be correct, Justice Rogers.
Because it is then said, well, the goods were, in fact, exported before that date, so they were ex hypothesi within 90 days from that date.
Yes.
Yes.
It's not absolutely clear, but that point is certainly made at a point in the affidavits. So when I say it's not absolutely clear, there does seem to be some swithering between the zero-rated invoices and the standard-rated invoices, but it ultimately comes down to reliance on the standard-rated invoices.
Yes, and if I must just reiterate that I really battled to see how there could have been a refund application for as long as the zero-rate invoices were the ones in existence. But I've heard what you have offered as a generous interpretation. Thank you.
As it pleases you, Justice Rogers.
Thank you.
Thank you, Justice Rogers.
Chief Justice, I just have one question. Thank you.
Yes, thank you. Please go ahead.
Thank you, Mr. Schulte-Douglas. On the basis that the 26th of March is the operative date, and I know you dispute that, and the calculation of the 180-day period, I've seen some of the submissions, the phrase is used within 180 days, but PAJA in fact says not later than 180 days, which is different. Within would suggest it would have to be done at least by the 179th day, whereas not later would suggest that the 180th day would be sufficient. But on that assumption, the High Court calculated that the 21st of September, which is a Friday, would have been the 179th day, which to me would mean that the applicant would have until the Saturday, the 22nd, to fall within the 180 days.
That is correct.
As it were, the papers only served on the 26th, which would have been the 183rd day, because of the public holidays in between. So if we hold the applicant to have to institute within 180 days, it would mean on the current timeline that the applicant would have had to do so by no later than the 179th day. And that would deprive the applicant of a right that PAJA gives in section 7.1, because any other time after that would not have been possible. At least we can take cognizance of that. The Saturday, the Sunday, the Monday, and the Tuesday would not have been possible. So on that timeline, why would service on the 183rd day then not be permissible? Because it would have been simply impossible to have done so by the 180th day, which the applicant was entitled to at the very least. And on your argument, the applicant would have to do so earlier than a time that PAJA provides.
Thank you, Justice Carlipin. No, with respect, there's a distinction between real impossibility, where notice cannot be given on a particular date, and those cases like Pinglides that deal with that, and this case where one's dealing with service of court process. So one must then look at Rule 4 and say, when does Rule 4 allow court process to be served? And it allows it to be served on a Saturday. It doesn't allow it to be served on a public holiday or a Sunday, but it can be served any time between 7 in the morning and 7 at night on a day of the week, including a Saturday. So it's not impossible. And then, of course, Rule 4 itself makes provision for various kinds of service that don't necessarily require the building to be open. You can affix it to the front door. That's one of the provisions of Rule 4. So with respect, it's not impossible. And that's the case that had to be made out. What was said was it was impossible to serve on the 179th day because somebody heard from somebody else that the offices had closed early. And that's not good enough. And if it is the Saturday as well, on which service could have been effected, there's not a shred of evidence as to why that couldn't have taken place. So there's no evidence of impossibility. And of course, we agree with respect that one doesn't want to deprive litigants or anyone of their rights to do things within time stipulations. And if it's impossible, then the court and the law will make allowance for that. But that's not the case. Yeah.
Thank you. Thank you.
Thank you very much. I don't see any further indications. Shall we go to Mr. Sonnepoel to reply? And after he has exhausted his 10 minutes, I will allow Justice Theron to ask whatever questions she still had last time when there were problems. Thank you. Mr. Sonnepoel, you have 10 minutes.
Thank you, Chief Justice and Justices. Firstly, may I commence by referring the court to Volume 1, page 59. This is the first request on behalf of this applicant for an extension of the time period within which to submit a VAT refund claim. In paragraph 6, which appears on page 60, it is made very clear that if the Commissioner persists with its view, then, quoting from the third last line of paragraph 6, Sasol Chevron may be entitled to claim such VAT as a refund in terms of section 44(9). In the next sentence, we therefore request that an extension be granted to, on this date, it was already conveyed to the respondent that new tax invoices were issued. But as I have argued earlier, with reference to what is contained in the bottom of page 60 in paragraph 10, it is clearly a conditional request, because at that time, the facts reveal that the attorneys acting for the applicant were also simultaneously acting for the supplying vendor, Sasol Catalyst, and it was busy in its attempts to convince the Commissioner that indeed this ought to be a zero-rated transaction. And if the Commissioner persists with his findings, then and in that event, that the extension be granted. Secondly, our learned friend argues that the replacement tax invoices has no effect whatsoever because the amounts remained the same. And he says this with subsection 1C of the Value Added Tax Act, which of course provides that if there is a change to the previously agreed consideration for the supply, if it has been altered by agreement, whether due to the offer of a discount or for any other reason, replacement tax invoices can be issued. If one has regard to the definition in section 1 of the VAT Act of the term consideration, one sees here that it includes a value-added tax And indeed, there was a change in the value or amount of the relevant consideration to be paid. The replacement tax invoices came into existence. The attorneys acting for both parties, Sasol Catalyst, the vendor supplier, as well as for the qualifying purchaser, Chevron, could not convince the respondent that indeed the sale of the movable goods ought indeed to be zero rated, and then thereafter, pursuant to payment of the amended consideration values which appear on the replacement or new tax invoices, Chevron went and did not request a VAT refund. Until today, no VAT refund has been requested. It merely persisted with its initial request of 6 July, namely, kindly extend the time period. If one has regard to volume 2, page 160, the answering affidavit in paragraph 33, there the deponent on behalf of the commissioner acknowledges that indeed there may be circumstances where, in paragraph 33, from the second last sentence, which is line 7, to the right of the page. However, should the vendor choose to pass this VAT on, it is not a given that the qualifying purchaser will be entitled to a refund, as the requirements for a refund from the VRA is prescribed in the regulation and traverse in this instance. And the only reason that one sees why the requirements were not met is, of course, the reason contained in the November 2017 decision in volume 1, commencing on page 89, and in particular, the three-line sentence on page 92, paragraph 5.4 of the November decision, saying, as the goods were not exported from the Republic within 90 days from the date of the tax invoices. Now, of course, if this reference by the commissioner, the respondent, to tax invoices is a reference to the zero-rated tax invoices, it follows that is quite illogical, because it is impossible for a qualifying purchaser to claim a VAT refund based on zero-rated tax invoices. It must be in relation to replacement or new tax invoices. So for that reason, we submit that indeed the conditional request for extension of the time period was a proper request. It was addressed only in the November 2016 decision, insofar as it is contended on behalf of the respondent that the reasons provided pursuant to the 6 December 2017 decision stayed the same. Of course, they did not stay the same, because initially in November, the decision was different. The decision then was you can't get the extension because you were late, and reliance had to have been placed on the old tax invoices. In December 2016, the decision changed. The decision is no longer you can't get the extension. The decision by the commissioner, who is not the VRA, is you can't get your refund. A refund was never requested. And then in March 2018, when the reasons are provided in paragraph 3 on page 112 of volume 2, what one sees there, I agree, there's no reference explicitly to the new tax invoices or the replacement tax invoices, but by clear implication, in paragraph 3.4, it speaks of, in the last line, nature of the original supply. At the time when this was written, whoever was the author thereof must have been aware, and we know from the facts that it had already been informed that there were replacement tax invoices, but it speaks of the original supply. It must be the supply in terms of the cancelled or old tax invoices. And there's no reason in here provided why the new tax invoices and calculation of the period with the reference to them cannot or ought not suffice. So we submit that indeed these reasons supplemented what was already stated, remained actually insufficient. The commencement of the time period must be with reference to the date of the reasons, 26 March 2018. Insofar as the reference to the calculation of value-added tax based on the so-called tax fraction methodology is concerned, clearly the part 3 of the export regulations only make provision for that type of calculation in relation to the responsibility of the supplying vendor to, in certain circumstances, pay tax. As soon as you get new tax invoices, there is no consideration of, it becomes unnecessary to consider whether the calculation should be with reference to the tax fraction method. We submit, therefore, that based on the not impugn new tax invoices, there's absolutely no reason why the extension, which was all that was ever sought, ought not to be granted.
2 minutes
Clearly,
left.
considering the May it please you, Chief Justice. Considering the provisions of PAJA, the decision maker was not authorized to take this decision. It was not a decision that was rational regard being had to what was requested. An extension was requested and a refund was denied. And that was what the High set aside and referred the matter back to the respondent for reconsideration. We therefore respectfully submit that the appeal ought to be upheld, as we have suggested in our heads of argument. With reference to the decision by the SCA in the matter of finishing tax, well, what we submit there with great respect is firstly that it concerned there an order that was issued, and when that came to the attention of the relevant party, in paragraph 7 of appeal, Rumpf, as he then was, and the matter of Republikeinse publicaties, we submit respectfully the present case where an application of a review nature that ought to be considered to be constitutionally compliant and in time cannot be referenced as against an old order judgment, that of Justice of Appeal Rumpf, as he then was in Republikeinse pers. It is simply not constitutionally able to attempt to construe the interpretation exercise that must be performed in relation to the statutes under consideration in that matter. In that manner. May it please you, Chief Justice.
Thank you very much. Justice Stron.
Thank you, Chief Justice.
Yes, you may put whatever questions you might have had.
Thank you. Thank you. Mr. Swanepoel, what prejudice has been suffered by the applicant as a result of, as you say, the SCA raising the delay point mero motu?
Well, firstly, Justice Stron, it could not address at a factual level the circumstances pertaining to the date on which actual service of the application occurred, namely Tuesday, 25.
Sorry to interrupt you. Sorry to interrupt you. Not on that point, Mr. Swanepoel. I'm dealing with the date when reasons for the decision was given and the calculation of the 180 days.
May it please you, Justice Stron. Insofar as that is concerned, it was expressly asked in the request for reasons. Tell us why it is said that we are not entitled to a refund. Prior to that, no decision, no letter, no correspondence, and no reasons were given why this applicant is not entitled to a refund. Bearing in mind, Justice Stron, with respect, it did not request a refund. And surely even then, until
surely, if that is the answer, that would have made a review case by the applicant unassailable. If at that stage the decision was taken under review and the applicant says, well, the merit of your answer is not right, then wouldn't the applicant hands down have won their review?
Justice, but the issue is, if one has regard to the request for reasons, which starts on page 107, dated 12 February 2018, the question was posed: why did you decide what you decided? You decided to decline a VAT refund request. No VAT refund request existed. There's no reasons for declining a VAT
and
refund.
Then on the applicant's argument, SARS gave reasons. Why didn't the applicant then take those reasons and on review?
Justice Tron, there were simply no reasons provided for rejecting a refund claim. Reasons were requested. Reasons were only provided on 26 March. And those reasons reveal, as I've earlier argued in paragraph 3, point 4 on page 112 in volume 2 of the record, that there was a change in the substance or nature of the original supply. That was the first time that the respondent placed reliance on that particular reason. And pursuant thereto, almost immediately, the applicant complied with the provisions of Section 11, subsection 4 of the Tax Administration Act, and thereafter, on the 179th day, Friday, the 21st of September, it issued out of the office of the registrar the application, and service occurred on the 25th. And the context of that, Justice Theron, is that did not, in its answering affidavit in the court of quo, state that this was a ridiculous request for reasons. Manifestly, when it gives the reasons, it says on page 112, here are the reasons in paragraph 3. It did not say you had them before. And even if one considers now the content of the reasons that were provided at a factual level, one sees it goes beyond what was stated previously, because this is a different type of decision that was taken.
Yes. Perhaps now I could ask the question again. What prejudice has the applicant suffered by the SCA deciding that point? Mero moto, as the applicant says.
Yes. So in this court, in Camps Bay Ratepayers Association said there are two circumstances where a court may raise mero moto non-compliance with Section 180. The first prejudice suffered is that the applicant was never afforded an opportunity to respond. And secondly, this court stated and directed in Camps Bay Ratepayers Association, paragraph 54 of the judgment by Justice Brandt, that it ought only to be raised mero moto if the period of non-compliance was inordinate. And yeah, it wasn't. It was a mere few days, not 3 years as in that case. So that is the prejudice suffered. It is not possible for the applicant to put its version for court. May it please you, Justice.
Wasn't this point raised as submitted by Mr. Shalter Douglas by the respondent in the grounds of leave to appeal before the SCA? At that stage, wouldn't the applicant have had an opportunity to deal with it? And also in this court, wouldn't the applicant have had an opportunity to place before this court the prejudice it may have suffered as a result of the SCA raising that question mero moto? And if the applicant is to be successful to persuade this court, surely it must lay out a basis as to why it's prejudiced by a court raising a point mero moto. For example, were there facts that went beyond the record for the SCA to make that decision? Was it not a pure question of law?
Justice Tron, it wasn't a pure question of law, and there are many references to what the sheriff did and did not do in the record of proceedings.
My question, Mr. Swanepoel, is didn't the applicant have an opportunity to place before this court or before the SCA the prejudice and the nature of the prejudice that it has suffered by the SCA raising that question of law, or if you say it's not a pure question of law, raising that question mero moto, if it did so?
Justice John, when the SCA raised this point mero moto, it was argued on behalf of the applicant who was the respondent in those proceedings, based on the judgment of this honourable court in Camps Bay Ratepayers Association, that the two circumstances present for the court to, with respect, raise that mero moto was not present. Firstly, it was not canvassed in the ARQUO proceedings pleadings at a factual level. Yes, Strong, I acknowledge that in the application for leave to appeal of the respondent, pursuant to which leave to appeal to the Supreme Court of Appeal, it raised that point, but it was not canvassed at a factual level. And secondly, it was indeed raised on behalf of the applicant in the Supreme Court of Appeal that it was not afforded an opportunity to provide its position insofar as this mero moto raised point is concerned. So therefore, that is the prejudice to be suffered by the applicant.
Has the applicant
the court, and it's right of Apologies, Justice Tron.
Has the applicant made out a case? No problem. Has the applicant made out a case that if it had more notice, there are further facts it may have placed before the court? And it has been prejudiced in not being afforded that opportunity?
There is no affidavit in which this is stated that forms part of the record of proceedings up to the stage when the matter was adjudicated in the Supreme Court of Appeal, Justice Tron.
Thank you. Thank you, Mr. Swanepoel. Thank you, Chief Justice.
Thank you. Thank you. If there are colleagues who have 1 or 2, 3 questions, or who wants to put questions, I am looking for indications, but I'm not seeing any indication.
Chief Justice?
Yes.
I just have one short question for Mr. Swanepoel.
Yes.
In regard to the 180 days, I accept that that one must, on the one hand, interpret this with a view not to placing fetters in the way of litigants approaching the courts. But on the other hand, the imposition of a limit of 180 days is clearly intended to impose some limitation. Otherwise, no time limit would have been imposed at all. If we are to consider what is the purpose of a period of 180 days being set for the initiation of the application, do you say the purpose is so that the registrar can know that there is a review application, or is the purpose so that the decision maker may know that their decision is being impeached?
I would submit with respect, Justice Rogers, it's the latter. And that is so if one has regard to the text of Section 7.1 of PAJA, which provides without unreasonable delay prior to stipulating the period of 180 days.
So the purpose of the 180 days is not so that the registrar, who's probably supremely uninterested in the matter, apart from administering the court, can know that the review is in the offering. Purpose, say in this case, is that SARS can know. Now, what does that then tell us? If one accepts that that the article clerk may go to the registrar's office and get the famous stamp on the notice of motion, but then for some reason it gets delayed deliberately or negligently and only gets served a month or so later, if the mere obtaining of the case number is the institution, then one is making notification to the registrar, as it were, the supreme purpose of the limit, instead of notification to the decision maker. And surely it's the decision maker whose interests underlie the imposition of the time limit.
Yes, Justice Rogers, there's nothing based on a textual or even a contextual interpretation of the provision of Section 7, subsection 1 of PAJA that indeed leads one to the ability to argue that it is for the purpose of the registrar to take notice of the matter, etc. Certainly the unreasonable delay must be interpreted to be a reference to informing the relevant decision maker of the review proceedings that is being instituted. But the context in which I submit with respect, that must be understood, is again, based on the facts of the present matter, that the delay was not inordinate.
It isn't the Section 7 says there mustn't be unreasonable delay, but at any rate, not later than 180 days. And I think the judgments, I'm not sure if they're of this court or of the SCA, say that 180 days becomes presumptively unreasonable. In which something less than 180 days may, in the context of a particular case, be unreasonable still, even if it's within 180 days. But 180 days is the last date absent some application for extension. So if we are concerned with why the lawmaker said not later than 180 days, it must be tied up with the decision maker being notified of that fact rather than the registrar.
Certainly, Justice Rogers, I cannot disagree with that type and that stated interpretation of the provision.
I don't see any further indications from colleagues, and therefore I think we have come to the end of this hearing. Thank you to counsel for your submissions. We are going to reserve judgment, and as soon as judgment is ready, the parties' attorneys will be notified. Judgment is reserved and the court adjourns.
As the court pleases.
Thank you. Thank you.
Today's proceedings have concluded. Now the host will terminate.